for judgment WA 968 of 2024.
It is dismissed.
To be mentioned, item number 2, WA 440 of 2024.
My lord, in item 2, my lord, I pray your lordship may kindly take up this matter next week so that I'll come prepared.
No, that was.
What is the purpose for which this?
Just a minute.
Sorry.
Mr. Bharti,
Yes, I have prepared short.
Did you find that rule 10 is?
Yes. Yes, madam, I have prepared short note kindly.
Where is that?
Rule 10A, 10B, coupled with
10AB. Is
Minor.
there any rule
yes,
called 10AB, which is
rule
mentioned in the order?
10AB coupled to rule 15. Welcome. My lord.
The civil judge has referred to 10 bracket small a.
That is
Bracket small.
that is capital A. Wrongly mentioned. That's capital A.
That should be capital A.
Yes,
So
that's-
that is the clarification which
Yes,
we require.
That's
Nothing more.
That is rule 10A. That is
So
capital A and capital B. I am also bring the rule, my lord. Kindly. I also bring the rule. I also bring the rule.
Counsel appearing on behalf of the petitioner has an appellant has agreed that there is a typographical error in the impugned judgment of the learned single judge, wherein there is reference to rule 10 bracketed A bracketed B small of Odisha Subordinate Education Service Rules 1972.
72, my lord.
Top. He states that in fact rules 10
And
capital A
my lord. Capital A.
and 10
Coupled to rule 15.
capital B
My lord.
of the said rules deal with grant of promotion.
My lord.
That's all. That was the clarification.
I am submitting names. Rule 10A clearly mentioned, and still I have given the rule. Clearly mentioned that person having 3 years in LSS cadre is eligible on selection. That is coupled to the rule 15. Rule 15 kindly see rule 15. Rule 15 say the word used promotion, and the rule 15 of the said rule. That I only read one paragraph, my lord. Rule 15(5). Notwithstanding anything contained in sub-rule 1, it shall be competent for the government to empower the selection board. Selection board referred to sub-rule 3 of rule 6 to exercise the powers and function of the committee, including those in respect of recruitment to the post of senior grade of service by promotion in accordance with rule. That word use promotion rule 15 coupled to rule 10, A, B and C.
The question is that we were dealing with,
Right.
the question is, you may be eligible, but whether it was your right
Yes,
from that date.
that
will
is rule
exam-
10B clearly mentions. The person has every
That
rule.
will exam, that hearing is.
And these clarification, this rule has been clarified by the divisional decisional court. That annexed in by.
All right, you have already
That I
made
understand.
submissions. You have already made your submission.
Yes, ma'am. That I annexed in the division decided that they are entitled to promotion.
The clarification having been, the position having been clarified,
Ma'am.
comma, list this matter for judgment. Oh, please, yes.
Orders item number 3.
Please, Your Honors.
Yes.
Minutes, the review has been filed. Challenging the order.
You cannot challenge an order.
That's a reconsiderations of the order.
Yes.
So on the ground of suppressions of material facts, my lords. A PIL has been filed, my lords, to revive a claim of 70 years old claim. my
Where
lords.
is, just a minute,
My lords.
where is the order?
My lords, may kindly have come to the orders, my lords, at page 16, my lords.
That's fine. You are party before the writ court.
Party before?
Writ court.
Yes, my lords.
You participated.
Not participated effectively
You
because, my
appeared.
lords,
You appeared.
because
You
my
were party. You are served with notice.
notice with right to file a counter. No counter has been filed, my lord. Because
Don't file, you don't file.
no, because paucity of time, my lord, sir. First date is what notice has issued, my lord. My lord, first date in PIL, my lord.
Counsel,
My lord,
please appreciate this.
my lord, my lord.
We are not the appellate authority.
No, no, I
Alright.
appreciate. I appreciate.
If you
my lord.
are aggrieved by that order, you can challenge.
It's not aggrieved, my lord. It's a fraudulent order has been passed, misleading this honorable court by annexing a fraudulent document, my lord. That is my question, Mark. If the order has been passed fraudulent under suppression of material facts, I have this court, my
Why
lord,
did
review.
you not bring that fact to the notice of the
Because-
court then?
Because, my lords, that's age-old documents which require times, my lords. What happened, my lords, may kindly see the writ orders
Right.
from past order.
Did you seek further time to bring?
Yes, I could have, but that is not allowed, my lords. First date, notice was issued. Second date, my name was not appeared in the cause list. Third date, judgment is passed.
To
my lord.
challenge that order.
My lord, this is a reviewable order, my lord.
No,
I
this is not
satisfied.
review.
That's
You are-
because
you are-
order
see.
has been passed in the suppression of material facts.
Mr. Counsel, please don't raise your voice.
My lord, I'm sorry.
The you could have challenged the ground which you are taking for review. You could have challenged that order before the Supreme Court.
These-
Not here.
Yes, ma'am, 226 and 215 enables this honorable court to correct the record of the court, my lords. Being the court of record, my lords, I have come with the judgments, my lords. I have come with the judgments, lords, may kindly have come to my.
Mr. Counsel, the judgment which you are citing here,
Yes.
you can cite somewhere else, not in review application.
So let's say suppression
Review.
of material facts, evidence, the main piece of the evidence has been suppressed in a writ court in a public
Mr. Swine,
remedy, my lord,
Mr. Swine,
my lord.
what is the number of opposite party which you are representing?
4 and 5, my lords.
4 and 5. We come to the judgment part.
Yes, my lords.
First ID.
Yes, my chief administrator, administrator Niti.
Is it your ground that Mr. Subrat Satpathy and Mr. Rayat Singh,
Yes,
advocates,
yes.
were not authorized or were not the counsel for opposite party number 4 and 5?
No, they are the councillor.
Please, sir.
Yes, they are council.
Please,
They have
sir.
appeared. Yeah.
So how can you
Then
make out
what
a
I
case now
what
for
I want
you?
to say, my lord, so my lord, that is
So you
problem.
are not appearing.
No.
Mr. Counsel, who was representing
Yes.
those opposite parties,
Yes.
you were not appearing.
No, my lord.
In that case, you had not appeared.
No.
You cannot appear. We will impose cost on it. You cannot appear.
I cannot appear in the review petition. my lord.
Yes. This is the law. This is the law laid down by the Supreme Court. That for seeking review, a lawyer cannot be changed. This is the law laid down by the Supreme Court. That we will hold.
Let me check my list.
Don't have to check. For seeking review, a lawyer cannot be changed. This is what the Supreme Court says.
So let me check my that.
No question of
I have
checking.
not come back with the judgments, my lords.
All
Let me
right.
check. Let me any day and let's make it.
All right. This review application has been filed on behalf of the petitioner who was representing on behalf of the petitioner seeking review of an order dated so and so passed in WPC number so and so. The petitioner in the present review application was duly represented in the writ proceeding, but through a different set of counsel. So stop. We are of the opinion that the prima facie opinion that this review application filed by Mr. Sunshine Anand Swine.
Announcement. Yes, is fine.
S.S. Swine on behalf of opposite party number so and so in WPC number so and so. This review application ought not to have been filed by changing the lawyer. So stop. Learned counsel appearing on behalf of the petitioner seeks adjournment to assist this court, list this case on 3 weeks.
May I
Much
submit
of-
one word, my lord? This is second review petition with 132 days delay.
One review application was filed by whom?
By him. First review petition was
You are
filed
for
by
the
him.
petitioner.
My lord?
You are for the petitioner.
Yes, my lord.
Mr. Bhaskar Pandey.
Yes, my lord. I will.
This is second review application.
No, it's a first review applications was filed, my lords, due to the circulars of the December circulars 23, the circulars of the Honorable Court, that matter was dropped because defect cannot be removed, my lords. That is, I have come with the judgments of the Hamad Supreme Court, my lords.
That just a minute, you have so many decisions
Yeah.
in your command, but whether the review application was filed,
Yes,
review application was filed through you.
yes,
You had filed,
yes.
not another the.
No, for me.
We'll see.
We'll check it. Published.
My lords, with the lord's kind permission, lords, may I be permitted to mention an out of list matter, lords.
Please give us.
I just prayed for 12th, subject to your lordship's kind consideration.
My lord, last occasion, your lordship allowed me to go on 30th. But it was not listed, my lord. The similar matter is posted to 11th. So kindly take up tomorrow, my lord.
Pardon your lordship, pardon
Yes,
your,
contempt matter, my lord. Right.
pardon your lordship, this is a PIL, this is a PIL.
Give your slips.
Lordship, I pray that matter may be listed on 11 since the conducting council.
We'll see.
Obliged.
Make a mention, my lord,
two identical matters, two different years. So we have two different benches. So lordship, kindly allowed only one bench to hear this.
Have you mentioned this? Have you mentioned this fact in your? Please do mention.
I mentioned.
Pardon, my lord. Item number 46 and 58. On behalf of Mr. Pippe Behra, kindly allow 4 weeks time. We'll file the rejoinder.
File
Sorry, counter.
46 and 58. Can't you mention when the matter is taken up? No.
The matter
Mention.
reaches, you mentioned, because we have to see what is the last order.
I want to make a mention, my lord, the appellant has challenged the order.
Wanted to make a mention, Your Lordship. Item number 20 and 2 days list. My lord's last occasion was to file the requisite, Your Lordship. Today we will file the requisite. So I may pray for
Let it be taken.
matter.
My lord, I may be pardoned, my lord. Lord, I humbly crave my lord's kind leave for making me mention in WA number 511 of 2024. The matter will be,
Give your slip, please.
my lords. And another two phrase admission appeals number 2927 and 2945 of
Give your
2024.
slip.
Yes, deeply obliged.
For judgment, item number 1, WPC 13557 of 2024.
This writ application is not maintainable since the petitioner, which is an unregistered association, is neither a juristic person nor has the locus standi to maintain this application. Any person aggrieved shall be at liberty to seek appropriate remedy under the law.
Item 2, WPC 15596 of 2024.
We have noted the facts and submissions. But finally, it is up to you. If you want to deposit, we can grant you time.
May I just pray?
Otherwise, we intend to dismiss it.
May I pray that? Oh, Lordship, may we keep an arrangement that from each running field, they should deduct from each running.
No, that we will not do. That we will not do. We have upheld the order rejecting your representation. All right. So in that background, if you want,
Your Lordship, may give me time to reposit it. I just in the alternative, I was praying for the reduction from the
wonderful. And senior counsel appearing on behalf of the petitioner has made an alternative submission. First off, it has been argued that if this court is not inclined to interfere with the impugned reason order dated 26/6/2024, the court may permit the petitioner to furnish the additional performance security within 30 days from today. Stop. Learned counsel representing the opposite parties does not have any objection if does not have any objection to the said submission. First off, in such view of the matter, considering the circumstance that there was some error in the RFP, RFP as noted above, we dispose of the present writ application with an observation and direction that if the petitioner furnishes the additional performance security in terms of clause 2.21 of the RFP within 30 days from today, comma, based on the letter of acceptance, comma, the opposite parties shall execute necessary agreement for the work in question. Look next. No order has to cause.
Orders. Matters under the heading for orders, item number 24.
Matters, there was an order directing for listing the matters. There were some connected matters.
Yes, madam.
What happened to those?
That has been delisted because this matter has been listed for orders. My IA, which I have filed for clarification, that has been listed. My lord, may kindly see, because this IA I have filed for clarification of the order dated 3/5/2021.
You said that the L1 did not come forward. Who?
And that is was the read petitioner. He filed the read.
No, but who's appearing for the state? So have you gone
I'm
through
ready
the
to my lord's repository.
Yes.
My lord,
I
may
mean,
kindly see the
petition-
prayer made in the read petition. My lord, may kindly see the prayer made in the read petition.
And the 21-23 has gone.
Yes, that is why I was placing the prayer, but it has become infructuous.
So why should you be asked to execute?
No. I have participated in the subsequent auction.
Oh, subsequent auction.
Yes.
Subsequent auction.
Well, my lord, can I see the prayer made in the writ petition at page 24?
Yes, 2021-23.
Yes. Well, that period has gone, so no extension can be granted so far as the present petitioner is concerned. And the prayer number 1 is he challenging the subsequent auction notice where he has not participated. I am the L2
Auction is
bidder.
under challenge before this honorable court in this read petition. The earlier one is not under challenge. The subsequent auction process is under challenge. Where the
Subsequent
petitioner-
auction process of the year 2021.
Subsequent.
L2, two letters are there. Just one moment.
So by
May I
lapse of
clarify?
time, the writ petition has become infructuous.
No, look at your, please read your prayer.
Prayer number 2, my lord, your second.
Yes.
And may further be pleased to issue writ in the nature of mandamus directing to the opposite parties, more particular to the opposite party of 4, to execute and register the lease deed in respect of Palasundapur sand bed for another period of 2 years, commencing from 21 May 2021 to 21 May 2021 for extension of period, my lord, only.
Not extension. This is
Yes,
execute
ma'am.
the lease deed and you have not
For
stated in
extension.
whose favor, maybe in favor of the High Court also.
No. Lease was granted for
No,
5 years.
I am looking at your prayer.
Yes, my lord.
Yes. So
years.
execute the lease deed. There is no prayer for
Extension.
there is no prayer for extension and that has been challenged. So what remains in this writ
That
petition?
is for extension of 2 years. Ma'am. That is the prayer.
That
number
we have
2.
to presume.
No, that is my prayer.
That is not your prayer. And in respect of whom also you have not stated.
For another.
So this
the petitioner,
unnecessarily
blood,
this
the
thing is
petitioner,
pending.
blood,
Where?
the petitioner, blood.
Where?
For the petitioner, blood.
Prayer 2, where have you mentioned petitioner? That is why I asked you to read it. Anyway, where is your IA?
Can you see the
IA?
I had flag Q.
Yes.
Annexon 9, if you lost it is clear from Annexon 9, page 53. It is clear from 9 you lost page 53.
This matter has come for orders on your application.
No, my application, my application.
Where is that?
I am the
IA
opposite party number 7.
10188.
Where is that application?
Flag Q.
What have you stated?
Well, I have stated that pursuant to the re-auction notice, I came out with the L2 bidder. And a notice was in Form F was issued to the L1 bidder, that is opposite part number 6. He did not deposit the required amount. So under Rule 27(9) of the Women's Rule 2016, so I have a right to be called upon to make the required deposit. Because the pendants of the writ petition, they are not issuing the Form F. That is why I filed the IA. I'm sorry.
Have you received copies of the IA?
Petition copy, I copy I received.
Yes.
I have no copy, my lord. I am not finding it.
You're not finding it because your office has not supplied. So that you have to collect. You've served copy on the state?
Yes, yes.
Are you sure?
Another copy, yes.
No, not another copy. Have you served? Because we want to be sure whether the section is complying with the direction that once you file any application, that application has to be sent to the office of the Advocate General. So anyway, whatever you do, we will take steps later that you serve a copy. All right. We're keeping it to next week along with the connected applications.
Lordship may clarify that pendency of the writ petition shall not be a bar.
That is already there. We need not clarify it again. That is there. When the case was entertained, that order was passed. These are the subsequent developments. What he says is L2 participate in the, so for that we are keeping it to next week so that you can obtain instructions. And there are three other connected applications which have not been listed. We are directing it to be listed.
Right.
Please ask the office why they have not complied with the order. On 23/9/2024, specific order has been passed for listing.
Yes.
You please ask that person. They can't do that when specific judicial order is there. How can they not? How can they not comply with that? Yes. In spite of order dated 23/9/2024, WPC number 13308 of 2021. WPC 36487 of 2021 and WPC number 3178 of 2021 have not been listed along with this application. Full stop. Full stop. IA 10188 of 2024 has been filed by one. What is the name?
Number 7. OP number 7.
Oh, you are a party in the case.
Yes, yes. I have been added. Later on, I have been added. On 23/9, I have been added.
Has been filed by, then why do you say intervener? Has been filed by opposite party number 7 for clarification of order, stating that for clarification of the order, copy of the application shall be served on Mr. S.B. Pandal, an additional government advocate, in course of the day in order to enable him to obtain instructions. List the case on 12/11/2024 along with the connected writ applications. 12th, you have some problem? 30.
Item 25. May I please, my lords?
Yes.
Item 25. May I please, my lords? My lords, here in this writ appeal, there has been a delay of 502 days. But I pray your lordship they have filed a reply to our IA also.
What is the point involved?
Point involved is, my lord, while bringing to the work charge establishment, wrongly someone was given, petitioner was given promotion as against the.
Filed a reply, there is nobody is appearing. Nobody is appearing. Who has filed a reply?
From the file, I found a reply filed to the IA.
WA 1663 of 2023.
1663 of 2023. Here I found a reply. That is why I submitted that.
All right. Just one moment, because no name is there and nobody is present.
I may be wrong also because.
No, you check the IA number.
Yes.
Sometimes they put the wrong number. So if that is there.
No, sorry, my lord. I was wrong. Another.
No, the notice has not been issued.
Question involved.
Because he was not ready. Yes.
Question involved is, my lord, while bringing to the work judge establishment, the petitioner was fitted against a post to which his qualification doesn't permit for that post. That is why he was reverted. The mistake was rectified. That was challenged in the writ petition. Writ petition was allowed relying on a judgment of the earlier judgment. That judgment says that it amounts to reversion. So before that, a notice is required to be given. That having not been given, it was allowed. Our submission for lordship is, it is a correction only, because admittedly he doesn't have the qualification to hold that post. He is class 8. The post requires metric plus ITI. He is class 8 only. That is how.
All right. What about certified copy?
Certified copy it is.
Please instruct your office and all.
In the meantime, certified copy has been filed. It is noted in the.
Yes, sorry, yes. IA 4500 of 2023. Then certified copy of the impugn order has been filed. Comma. First, please write, this application has been filed for dispensing with filing of certified copy of the impugn order. Full stop. Certified copy of the order has been filed in the meanwhile. Comma, rendering this IA infructuous. Full stop. This IA is accordingly disposed of. IA number 449 of 2023. How many respondents?
The respondents, my lord, 3 possible.
So, issue notice. IA 4499. I issue notice to the sole respondent on the question of condonation of delay through speed post / registered post with AD returnable within 4 weeks. Comma, requisites for which shall be filed by
3 working days.
By 8/11/2024.
My lord.
List the case. 6 weeks.
6, 17, 12.
Yes, list the case on 17/12/2024.
Item 26.
26, my lord. Here, there is a delay of 554 days. Delay.
Yes, what is the issue?
My lord, my time.
Malayalam the directive that rules governing on the date of death of the employee, that will govern.
Yes, we will
Relying on a judgment rendered by the honorable.
give you some.
In response to your lordship's. In response to the notice.
When did the new rules come into force?
17/2/2020. 2020.
He says date of death.
But this is not the issue here, my lords. Here the issue is, my lords, there is a delay of 554 days and there is no explanation in the.
So you mean to suppose you discussing is not relevant?
No, new rule is not relevant, my lords.
No, you are saying that is not the point. What I was saying that
Yes, my lords.
Yes.
The point is, my lords, the father of the petitioner died in 2011.
Yes.
And the petitioner is the 6th legal heir of the deceased employee. And she applied because the mother by that time.
6th legal heir means no other legal heir was there.
No, above the petitioner, above the respondent, my lords, there were other 5 legal heirs.
They were all employed.
Sisters. No.
Then?
Mother had already attained 55 years.
No, that is all right. What about the other legal heirs?
Other 2 married daughters. Daughters and other 3 were illiterate, my lords.
Where?
Other 2 were plugged metric, 1 is illiterate. So this petition.
So, but no one was eligible.
Yes.
Is this your case that no one other than the respondent was eligible to apply?
That is because.
No, was the respondent eligible to apply because she was 16 years at that time?
No.
She was 16. Elder
sisters, only the daughters. There are six daughters.
All are 6. Okay, 6 daughters.
6 daughters. two married daughters, legal,
No, past metric.
One of them has passed.
One has passed metric.
this respondent.
No, you said two more were there? Two married sisters?
Yes.
Okay, they were not interested.
Yes.
Okay.
Other two married plugged metric.
President, should the authorities wait for you to acquire qualification?
No, the respondent had the qualification.
The respondent had the qualification,
Yes.
but respondent
And
was not eligible because of age.
Other legal heirs mailers, they gave their no objection affidavit.
We are in
That is also there.
2024.
Mr. Mahanti?
Yes.
When she applied, she was not eligible.
Yes.
In 2011, she was not 12, she was 16 years old.
Yes. In 2014, she attained the age of 18 years. And she made the application.
First, the application had been rejected on the ground that.
No. First application was returned. That is there in the synopsis mailers they have filed. First application made by this present
Yes, was
respondent.
returned stating that after you become a major, you apply.
After attending, you apply. She applied, and the matter was inquired into by the collector, the distress condition.
Condoning the delay because this requires hearing. We are condoning the delay.
Because, my lords, I am just bringing to your lordship's notice, my lords, this issue that applying rule 2B of the 1990 rule that has already been settled, I am providing. Your lordship, I am submitting the judgments. That is also.
So we can't consider that unless we condone the delay.
Yes, sir.
Yes. So that is why we are condoning the delay. Then we'll hear your submissions.
Yes, well, obliged.
That is what we are saying.
So far, delay is concerned.
We are not allowing the writ appeal without hearing you.
So far, the delay is concerned, my lords. Delay of 554 days. There is delay of 550 days, and there is no explanation. There is no sufficient cause, no explanation.
Therefore, we are imposing cost 20,000 payable to the
Respondent.
All right.
I'll leave you at your lordship because
We fix a short date.
my respectful submission before lordship that so far the merit of the case is also concerned, my lords. That is the issue has already been settled, my lords. I have the judgment.
What is the judgment?
Yes, I am providing. When the other legal heirs,
Can you address on merits?
sorry, well,
Can you address on merits?
right now I'll have to take 1-2 days.
Okay.
Yes.
Give the citation.
Also another case, my lords, it is Honorable Appeals Court also dismissed the self-eval. Another. Anybody from the family can apply. The possibility that is that as well. Others have no objection. Other legal heirs have no objection, my lords. Because
All single judge decisions.
yes, sir. And this one, my lords, Subhash Chandra Khatua, that went to Honorable Supreme Court, and the person has got the appointment, madam.
Please note down and.
My-
note down.
Why are you relying on you?
You're saying covered by a Supreme Court decision? You're
There
saying
is-
covered by some Supreme Court decision? You said it's given all of the High
In
Court only.
in WBC number 22678 of 2020 mailers, Subhash Chandra Khatua, that
Is it a reasoned order?
state went
Is it
to.
a reasoned order?
Yes, only 2B has been dealt with. Rule 2B of the OCS 1990 rule. That
All right, we'll consider.
Yes.
Listing it next week. You go through the decisions and bring your, be ready also. All right. On the, as agreed between the counsel for the parties, list the case on 12/11/2024. The learned counsel for the parties, yes.
27.
Lordship, in item number 27, as per the noting of registry, there is a delay of 91 days in filing of the appeal.
I have no
The
idea.
respondent have
I
appealed.
have no any objection.
All right. IA R3. R3 is your own
Your
official.
lordship,
All right.
pro forma
All right.
register.
R1 has appeared. Likhite Mr. S. Sahu. You are Mr. Siddharth.
Your lordship.
Mr. Siddharth Shankar or only Siddharth?
Siddharth Sahu, your lordship.
Okay. Petitioner Siddharth, appellant is Mr. Siddharth Sahu and respondent Mr. Umakant Sahu. All right. Heard learned counsel for the appellant and respondent number 1, Mr. Umakant Sahu, learned, considering the fact, the name Mr. Umakanta Sahu, learned counsel for the respondent number 1, submits that considering the period of delay, which is how much?
91 days, your lordship.
91 days. He has no objection if the prayer for condonation of delay is allowed. Full stop. Considering the said submissions and the considering the said submission, the IA for condonation of delay is allowed. If the delay is condoned, the application is disposed of. Have you served a copy of the appeal memo on him?
Not, no, sir.
Appeal memo I have not served.
So if you have a copy now, you can. Do you have an
course of
extra
the
copy?
day,
Mr. Sahu, learned counsel for the appellant, undertakes to serve a copy of the appeal memo on learned counsel for the respondent by tomorrow. List the case for fresh admission on 19/11/2024.
Yeah, there is a pencil matter.
12/11/2024.
28 same.
Item 28.
Same.
28 is same. Your lordship.
Same order.
Obliged.
Item 29.
Period of delay is also the same.
Your lordship.
29.
On behalf of Mr. Retiral, your lordship. So last occasion, lordship was ordered to file the requisite.
Yes.
Lordship, today we will file the requisite. So
You are Mr.
SR Acharya. My
Mr.
power is not there.
You are appearing on behalf of.
Mr. Biswa, MK Biswa.
Okay, your name please again.
SR Acharya.
Mr. H.R. Acharya, learned counsel, appearing on behalf of Mr. Mittu Kumar Biswa, learned counsel for the appellant, submits that the requisites, that the postal requisite shall be filed in course of the day. Is there any? I don't think there is any interim order.
No, your lordship.
Undertakes to file requisites in the course of the day. If requisites are filed as undertaken, notice shall be issued, returnable within 4 weeks. Returnable within 4 weeks. Case shall be listed on Quebec.
16/12.
16/12/2024. 17/12. If requisites are not filed, the writ appeal shall be dismissed without further reference to the bench.
Yes, grateful.
Not filed as undertaken, the writ appeal shall be dismissed without further reference to the bench. Yes.
Item 30.
May I please? The Union of India has filed this writ appeal, my lord, challenging the order of Honorable Single Judge. Earlier, I have filed a writ appeal in which there is a delay of near about 65 days that has been condoned, and subsequently on 13th January 2024, this has been disposed of, granting liberty to file a fresh writ appeal because some of the documents has not been annexed. But subsequently, I have filed this writ appeal on 30/8/2024. Though the office has pointed out 588 days delay, but in fact, there is a delay of near about, so far my calculations concern, 180 days.
So what you have explained, submitted now, have you stated in the IA? You have not even stated about the date of filing of the writ appeal, earlier writ appeal.
In synopsis.
Please look at
Yes,
your IA.
I have not stated.
Yes, why not?
Synopsis and date set I have.
No, we have to look at your IA and consider that. All that you are saying, why have you not stated in your IA?
Additional evidence.
You file an additional affidavit.
My lord.
My lord, I have object the limit. I have certain judgment also, 5-6 judgment I have.
Disposing of the IA today.
Yes, ma'am.
And those facts are there. If the
Yes.
earlier writ appeal had been entertained after condoning the delay, we can. But all that he has to bring to our notice.
Yes.
All right. Mr. D.R. Bhopta, learned CGC, prays for short adjournment. How much time do you
7
need?
days. Within 7
Prays for a short adjournment in order to file an additional affidavit in the IA for condonation of delay. In order to bring relevant facts on record. List the case on
18th
List the case on 19/11/2024.
Obligement.
What are those judgments, Mr. Counsel?
My lord, I have a judgment.
On which point?
Condemnation of delay, regarding condemnation of delay,
Condemnation
rejection
of
of,
delay.
I have say 6 judgment I have collected.
All right, there are 100 judgments, Mr. Counsel.
The best thing you give, your best judgment you say.
Yes, Honorable High Court and also Supreme Court, my lord.
Have you got only judgments in your favor or other side also?
No, my favor, my lord.
31.
Last occasion, Lordship directed for to take instruction as there is 1717 days delay, my lord, in a matrimonial appeal has been dismissed for default.
Yes. Here your petition for divorce has been dismissed. Why don't you file a fresh application? Why should be dragged to court after 4 years?
My lord, ସେଟାରେ ବି ତ delay ହେଇଯିବ ନା?
କଣ delay ହେଇଯିବ?
The decree ଟାକୁ challenge ହେଇଥିଲା.
କୋଉ decree ଟାକୁ challenge ହେଇଥିଲା? That has been dismissed. Has your application for petition for divorce been allowed? It has been dismissed.
Dismissed. But that is a challenge before the Honorable High Court, my lord.
Yes.
Even now, I will again file the same. It will be res judicata and there is a delay of.
In respect of the condemnation of delay, there's a delay of 1412 days. Yes, that's what I'm saying. Your husband can file for divorce.
In fact, you want to drag.
My lord. But they are
We have the
separate.
ways and means.
My lord.
We have the ways and means to deal with such litigants.
My lord. Your lordship directed last occasion that you will lordship.
When was the suit filed? When was the matrimonial suit filed?
Filed, my lord, in the year. Uh, 2011, my lord.
2011. And when was that dismissed?
2019. No, my lord.
2019.
Decree was passed here there in the lower court, my lord, in the year 2014.
2014. You filed your appeal.
My lord.
That
For
remained
this
pending.
This is honorable court. This is now pending.
We understand. And we are in 2024.
My lord, because of my mistake.
No, not your mistake. Because he is enjoying the luxury of litigation.
No, my lord. The wife is taking alimony by filing the 125 proceeding, my lord,
How
in
much?
the court below.
How much?
My lord.
How much?
And last occasion in the year 2004, my lord, the order passed. In that time, 2000 rupees was allowed. Now I have not instruction, my lord.
So she must be getting more.
My lord.
इसको कुछ cost करता है. We intend to impose cost.
My lord, requisite has been filed, my lord. That is the court message, court process that was issued. But deliberately the wife is not receiving the notice, my lord. Therefore, court has directed me separate for paper publication, my lord. But it was listed. I have oversightedness and sleep the lease, my lord. It was dismissed for default.
We will impose such conditions that he cannot approach court anymore.
My lord.
It's too much.
Notice had been, you had agreed to take notice by special messenger.
My lord.
That also could not be served.
My lord.
Oh, true, this was long, yeah. All right, what is the address of the?
My lord, address is in the my main petition, my lord. The care of is Bonamali Behera, my lord. Care of is Bonamali Bonamali Behera at Dhaudi post Balarampur. I have not mentioned in the my CMA PL petition. It is I have wrongly skipped, my lord. The main address was listed, but in my petition it was there. I have filed a consolidated petition, cause title, my lord. In that I have corrected the address. This is my corrected consolidated cause title. I have already filed in my Mata, my lord.
When was the marriage?
Marriage in the year 95.
No, but the address was.
After 1 year, they have
Notice,
separately.
notice was sent to which address?
My lord,
Notice was sent to which address?
Dhaudi Diha, care of Balaram Bonamali Behera at Dhaudi Diha, post Balarampur, PS Ghosipura.
At present, you have given some address.
That
is the wrong address.
No, wrong. I have skipped the present address, my lord. It is in my Mata petition. The
All right, we will pass orders. This is case for orders. Please.
Lordship, may kindly permit me to correct the CMAPL present address to be written, my lord.
No, we are not required. We will dismiss this application with cost substantial.
My lord, kindly forgive me my giving my one chance.
No chance.
My lord, kindly be.
Sorry.
Wife is taking
Item
alimony
32.
is there, my lord, and they are not living since 1995.
We will
my lord.
entertain your application only if you give an undertaking that you will enhance the maintenance to
My lord.
10,000 per month.
My lord, if she will come, my lord, they were now old days. At the old days, my lord, that son is now 26 years old. And now he is living with her mother, and they are
So
now.
why should an old lady be dragged to court after so many years?
She is, my lord, she is now contesting case at the lower court.
So
Now
let her
it will
come
be
to the lower
settled
court.
here, my lord. She will take the permanent alimony and settle the matter. If
So
she will
old
come to
people
here,
is necessary for divorce.
my lord,
Had you been young, we could have considered that you will remarry. At this age, what is the necessity?
she has also not, my lord,
Wasting time.
Yes. List on 26/11/2024 for orders.
Item 32.
Third learned counsel for the appellant, for the petitioner. List on 26/11/2024 for orders.
32. Sir.
my lord, it will be dismissed.
IA 32. IA 11582.
I have to file.
This
Beg your
IA
pardon,
has
my
been
lord.
filed for modification, clarification of order dated 6/8/2024. Peruse the order dated 6/8/2024. There is a typographical error, paragraph.
It's para 3.
Paragraph 3, where the word revoke has been typed as invoke. The order is correct, shall be corrected, and the corrected order posted on the website.
Great for that.
I is accordingly disposed of.
Order shut down. Item number 5.
Petitioner and Mr. Ponda, you are in that which we have corrected the order?
Yes.
You are there or Mr.
Yes.
Kaur is there?
No, I am there.
It's correction of order.
The correction of order, I am.
Yes, Mr. S.B. Ponda and Mr. Kaur. A small error.
Yes,
typographical
invoke,
error.
revoke.
Item 5.
My friend. Yesterday you also wanted to see the brochure, the admission guidelines.
But the fact remains that as on date, you don't have any caste certificate.
It was not issued to in my.
Not issued to you then.
My lord, just despite not granting stay in the writ appeal also, the Tahsildar relied upon the earlier reason,
Maybe,
which was not accepted by the Sanul court.
maybe.
No, but as per the admission guidelines, you should have a certificate.
I
That is what.
the
But they have granted you time for production.
for production.
Our brochure is very specific.
But I'm my lord, in a tight position because my lord,
We understand, but what to do? You are, there must be others also in your position. So what to do? The rules are same for everybody.
my lord, the action of the Tahsildar, my future is last year your lordship granted me the liberty in the writ appeal. I couldn't take admission in 23.
Mr. Counsel, your future, you are concerned about your future. But think of someone who has the certificate.
No, but I understand, my lord.
No, think of someone else who has the certificate of SC, who can produce, he can be considered, he can be given that position, that seat.
So what they are saying.
So this is the difference. This is the difference between you and someone who has the certificate.
But that
So you are concerned about your case, and we are concerned about that candidate also, in whose favor there is a certificate.
But
So these are admitted facts, and we cannot issue certificate.
No, I'm not saying it for issuing the caste certificate. Only say my little prayer is the Tahsildar who has rejected it deliberately in violation of the order of passed by this one was directed to issue fresh certificate.
We understand. That is under
different,
challenge.
different.
That is under challenge. That will be seen.
Our guideline manner specifies that he must produce the caste certificate.
Where is that?
I totally agree. The third page, my lord. Third page of that guideline.
Third page I will be seeing.
Third page.
That is the only thing, clause
Page
2.
3,
Before, down below the note.
Note 2.
Note 2.
The SC/ST candidates must produce caste certificate from Orissa state only to get the privilege of reservation in category in Orissa. That he has not. That provisional was granted only because he produced his father's certificate that your lordship finds at page 69 of his writ petition.
No, that I admit.
No, that was also cancelled.
On the basis of
So,
undertaking, I was given admission.
And we
I
knew
have-
the background also of his litigation. So we granted him provisionally.
Yes, that I am obliged to the authorities, my lord. But my predicament is that
Now
the
you are-
3-8
That their predicament is if they grant you a seat, subsequently it will be cancelled. Another
That is
candidate will be deprived.
But for a moment, you may kindly consider. 3rd of August 2023, the judgment was passed by the Honorable Court, directing him to issue forthwith the caste certificate.
Still holding forth, or it is under challenge.
Yes, my lord. Under challenge, your lordship didn't grant stay. That at page 7.
Mr. Counsel, did the High Court grant you certificate? Can the
No.
High Court grant certificate?
No, never.
Certificates is to be granted by the Odisha government. That is not with you. And that is one of the requirements. We cannot deviate.
My lord, may I have a little prayer, subject to acceptance, your lordships. The Tahsildar, who is the competent authority under the 2024 rules, he may follow the rules and issue a caste certificate according to him. Whatever, follow the rules in terms of the judgment rendered by the Honorable Court and the 2024 rules mandating the procedure to be followed for issuance of caste certificate.
Sorry.
Within a period of 3 or 4 days or a week, that will suffice the purpose.
That is not. You are not eligible.
My lord, for a moment, you will kindly see page 78.
Business corporation.
78, 78 and 79, you will kindly see. So page 78 and 79.
We'll see everything, we'll write order. We are not satisfied.
But it will be last year, my lord, I couldn't take admission, my lord, despite your order passing in my favor. My lord, this year I have already taken admission, and in
Can I have a small?
Yes.
Submission? We have to, today is the last date.
We are taking the.
So we have to be some liberty that we'll fill up with the next candidate, next available candidate.
my lord, one thing may I pray, my lord, in terms of the Act, 2011 Act, and because read with the rules, 2024 rules, and read with Madhuri Patil's, my lord. You lords may kindly render indulgence for the. No, I am not saying that. I am not saying. Yes, that is what I am praying, my lord. Only in this case, the.
Direct in this case, you can only issue a directive to them.
No, I am not saying that direction to the Tahsildar to issue caste certificate, my lord. You lords may kindly protect me for the admission.
We
That will
cannot
be
go
honorable
against law, Mr. Counsel. We cannot go against law. The present writ application has been filed seeking direction to the opposite parties. The admission has been cancelled.
No.
No,
I'm still continuing, my lord.
Now today we'll call the next candidate and give him admission.
Today is
Please
the
come
last
to
day.
paragraph 1.
They are threatening to cancel, my lord, on that date.
So on document verification, he could not come up with the.
Seeking a direction
Officer can.
by restraining the opposite parties from cancelling the petitioner's admission to MBBS course based on which examination?
NEET 24.
NEET.
NEET 2024. Stop. Next. The petitioner claims that he belongs to scheduled caste category.
Scheduled tribe.
Scheduled tribe category. Stop. It is an admitted position, however, that the petitioner does not have a certificate in his favor to the effect that he belongs to scheduled tribe category. Stop. Why was he given provisional admission?
On production of his father, that's page 69.
Temporary caste certificate.
On production of his father's.
Temporary certificate was issued by the authority, that's why admission and undertaking.
The petitioner was allowed provisional admission to the said course on 1/9/2023. 24. As he had produced a caste certificate which was issued in his father's name.
Why and welfare of, it's not a proper caste certificate also, you know.
Second, so temporary caste certificate and an undertaking.
Temporary caste certificate.
It's not even a valid.
Just temporary caste certificate issued in his father's name and on taking given by the petitioner that he shall be submitting the valid caste certificate in terms of the guidelines before
The OJE.
no,
OJE.
when by which time
By today.
It was 28th was the
Before
date.
the
but we
college
extended
authority
it.
for admission, man.
28
They have to produce it before report for the admission. At that time, they have to.
28 by 28 11 28 10 2024. Stop. Next, the fact remains that the petitioner had applied for admit an application for issuance of caste certificate in terms of an order passed by this court dated so and so. What is that?
3rd August 2023.
23 passed in
WPC number 16069
For
of
stop.
23.
The Tahsildar has rejected the said application of the petitioner.
Without communicating me or without date.
When?
No date was given. In an undated order, without communicating with me.
Full stop. It is the petitioner's case that the rejection by the petitioner of the petitioner's application for issuance of caste certificate has not been communicated to him. And therefore, such a rejection is invalid. Full stop. What about his father's case? His
Writ appeal is pending.
Writ appeal is pending, Your Lordship.
no.
Was cancelled.
Cancelled.
Other certificate cancelled. He filed in a writ application unless
By the Tahsildar.
rejected his petition against.
Sir, his application, his certificate has been cancelled.
Yes, Your
Yes.
Lordship.
File a writ petition challenging that.
Challenging that.
Father.
Stay was granted.
That was
And
it was also
ultimately,
dismissed. Again, he has challenged
writ
the
appeal is pending.
Dismissed.
Writ appeal not dismissed. You will not interfere since the term of election was over. So we will not interfere. That was no, not even allowed.
I think that better
It is an admitted fact that it is apparent. It is an admitted fact that the petitioner was granted granted admission to MBBS course on the sole basis that there was a caste certificate issued in a temporary caste certificate issued in his father's name to the effect that he belonged to scheduled tribe. So stop. It is also not in dispute with an undertaking that the petitioner shall be submitting certificate in accordance with the guidelines for admission to MBBS course 2024-25. Stop. It is also not in dispute that the said temporary caste certificate said to have been issued in favor of the petitioner's father has subsequently been cancelled.
No. Temporary certificate in my father's name was issued way back in 1988. It was cancelled by Tahsildar in 2007. In 2008, I filed the writ application, and it was sometime in 23. It was this.
So that 23 order was not passed in your case.
In my father's case. So the writ appeal to 2257. Ultimately, it was not since the elapse of time, the term was over. That's why it was.
was cancelled.
Huh.
Father. Father had a permanent.
Yes,
Father had
1988.
permanent.
Yes.
Father?
Father had permanent caste certificate.
Yes, Your Lordship, that was cancelled.
Was cancelled. Stop. The petitioner's father had challenged the cancellation of the caste certificate before this court by filing writ petition.
Yes.
Filing writ petition
WPC 15 of 2008.
being WPC 15
15
of 2008,
8
which stood disposed of
on
later by an order disposed of on
my lord. One 12/2022.
1/12/2022. Post office. Apparently thus, when the petitioner's father, as on date, does not have a certificate to the effect that he belongs to scheduled tribe. Stop. The petitioner does not have any certificate of him belonging to scheduled tribe. Stop. In such view of the matter, the petitioner cannot claim admission to MBBS course against scheduled tribe seat. Stop. This application has no merit and is accordingly dismissed.
The other family members are having caste certificates. My mother is having. She was elected as a chairman from a reserve constituency. My uncle is also a government servant. All of them have been issued with caste certificates.
That is the operative portion. If some facts are to be mentioned in the order, you will
He
see.
may be given a liberty to proceed with.
That liberty is there. The writ petition is dismissed. It goes without saying that the opposite parties shall be at liberty to proceed for filling up the seat against which the petitioner has been allowed provisional admission.
Provisional.
Still,
Item number 3.
Since your lordship's order,
My appearance for National Medical Commission.
since the order was not stayed, my lord, your lordship may kindly reconsider that.
No, I have received the copy. My presence will.
Item 3, sir. May I please, my lords? In item 3, I find there is an order from this honorable court on 29/10/2024 to take some instructions. It has not been received.
What my lord wanted to know is whether the person who has been posted to my institution as principal, whether he is continuing as a principal in other college.
The only question is,
my lord,
that whether a person can be given dual charge of 2 colleges as principal. That is the issue.
That is the order, my lord. They have not, I've got the collected copy on the net.
No, that is factual aspect, but the legal aspect is that whether
that's correct, sir. That is
a
provision.
person can be given dual charge or not. Where is the provision for appointment of principal? Yes, Mr. Mishra.
I am appearing for the opposite part number 4, man.
Yes. Opposite party number 4. Who is opposite party number 4?
The person, the writ petitioner.
Writ petitioner.
No. My friend has come up on writ appeal. I am for the writ petition.
So your writ petition has been allowed.
Not definitely allowed.
Both are unhappy.
They joined in one date. I am senior in age, but the court has directed a third person will continue as principal in charge.
Right.
But the law is The government circular is the senior most person of the institution.
You are right.
Is to continue.
You are right, but whether this arrangement
This
can
is
be-
a,
This is an
this arrangement is
Temporarily.
incidentally, I was appearing when I was on the other side. I was also appearing in such cases. In those cases, the honorable single judge has, for the time being, has given direction to the authority concerned to give the responsibility to a nearby college principal, senior member from the nearby college. Sorry.
temporary. And my lords have not interfered.
No, that is not.
order. My lords have not interfered. But met, cadre has not yet been, may I answer,
Yes,
my
it
lord?
has not been
The
filed.
fact, the law, what is the governing the field? As per the section 10, a cadre is to be constituted, 10C, my lord. And a cadre control.
No, we are not on that.
Yes, my lord.
We understand the cadre is to be
My
there, the seniority has to be decided
Thereafter
accordingly.
transfer.
There are two questions.
My lord.
One, in such cases where there is a serious dispute about the seniority, learned single judge worked out a method where person from outside can be brought to that college, senior to both of them, and
Yes.
he can be appointed principal. This
There
is
is
one
no-
thing.
There is no problem.
This is one thing. But where pursuant to that decision, see, an arrangement is made where additional charge is given to a person who is already holding charge. Whether that can be done or not. Therefore, we want to know
Yes.
what even
There is no,
even temporary, because we don't know
under the statute,
and running two colleges is not easy.
that
No,
is
subject to
there
my
is no such
acceptance.
provision.
Now, subject to my lord's acceptance. Seniority inter say there is a dispute between the writ appellant and the writ petition. Now, the honorable single judge ordered that later cadre be worked out and the third person be kept there. Now, the only thing, as my lords have correctly pointed out, because he's already a principal in charge, now how he will be functioning here? In addition, he is junior to both of us. Now, my lord, subject to my lord's acceptance, now my lord may direct any person outsider senior to us be kept there as principal, or my lord, since our dispute is there, my lord may direct the next senior most person of the college be kept as principal in charge.
What the honorable single judge in that
Yes,
Remolata
that is my
let
submission.
him complete.
And
What
on
the-
merit, I will be ready. My lord may give me
No,
seven.
but where is the rule for appointment of professor in charge?
Principal in charge. Man. I have given the circulars also. What happened, my lord? The state government, there are two circular issued in this field because there is no post of principal as such. Principal, there is no such post is created in a private institution or in an aided institution. What is the arrangement is the senior most teacher. When the institution is aided, the senior most teacher shall continue as principal in charge.
Where is
Till that is the government circular, madam.
Where is that?
Yes, I have also given it is added. I have given the added circular. Hello, page 29. And after the added, just I'm clarifying the position, madam. This is the position of and after the institution became aided, what is the condition they have imposed? A person is a reader. Reader includes the post of principal. That is Rule 83 of the 1974 rule, under which all these aided institution employees are governed. The rule says a reader who is constituted from the common cadre will be posted to as per their seniority, they will be posted as principal of different aided colleges. The dispute for this honorable court was the cadre structure has not yet been finalized. That is why in that Premalta Raut case, my lord, this honorable court has directed you publish the gradation list. Thereafter, as per under the inter-transport rule 1979, there is a rule, my lord, for the aided institution. Under the rule, my lord, after the man come into the cadre, he only permissible to be transferred to different aided colleges in his cadre. So till date, since there is no cadre, no transfer is permissible because of 79 rules. Man. This is the position. That is why at that stage, my lord, Pramalta Raut case come into the picture of this honorable court. And this honorable court says, you constitute a cadre, the honorable single judge, my lord, you constitute a cadre. And till then, whatever the arrangement will made by the concerned director or the government, that will hold the field. The director in this particular case, since I am the senior in age, though both of them have joined in one date. Director need to continue as the principal in charge of the college. This was the arrangement. That was challenged by my friend before the Honorable Single Judge. The Honorable Single Judge, without deciding this issue, by following this Premolata Raut case, has directed, let a person from the outside other institution be kept in charge of this institution. Now the position is, the other person as a principal of another Somanath High College, he has been directed to function dual charges. There also he is the principal, here also he is the principal. So now this type of arrangement is not permissible anywhere in the rule. I didn't find a provision in the statute. So that is why, my lord, if the Premolata Raut case, my lord, I have given the last time a copy, I am just reading out what the Honorable Court has said. Till constitution of such a common cadre, the interim arrangement made by the state with regard to appointment of principal in charge in different aided colleges in terms of the provision of Rule 3 of the 1974 rule shall continue. Here, my lord, since there was admittedly no cadre, the government has passed an order in my favor because I am the senior. Kindly see, my lord, page 35, annexure 7. Is following that Premolata Raut case. That here, this is page 35, my lord, which was impugned in the Honorable Court. Consequent upon superannuation of Jyotirmoy Nanda, ex-lecturer in anthropology.
When was that order passed, Premolata?
Pardon? Premolata, my lord, I have given, this is one, I have given 2 copies.
11/5/2023.
11/5/23. This is one, I have given 2 copies.
11/5.
Again. This is the judgment by the Honorable Single Judge. My lord, kindly have a glance to that.
Who had appointed you the principal in charge?
Yes, page 35, government. Director. Who is the cadre controlling authority? That is at page 35, man. Consequent of, shall I read, man? Consequent upon superannuation of Srimati Jyotirmoy Nanda, ex-lecturer in anthropology, the approved principal IC, and on recommendation of the sub-collector Bhubaneswar cum president governing body of Bauri Bandhu Higher Secondary School, Chhatawar, district Khurda, Sri Siharsa Mahapatra, lecturer in history, is hereby allowed to act as principal in charge cum secretary of the HSS in addition to his normal duty until further order. The principal cum secretary is also allowed to make all financial transactions on behalf of the aforesaid higher secondary school. The selection of name of Sri Mahapatra for approval of principal in charge cum secretary GB of the higher secondary school is based on the ratio decided by the Honorable High Court in the case of Kamalakanta Das versus State of Odisha and so with the batch of cases. That is another case where a government circular was challenged. There, my lord, the court has said, if the judgment, the joining date is 1, the seniority base will be decision. That will be judgment. And
Yes.
Premolata also follows.
Why the state is not coming out with cadre, with the seniority?
It is not.
Other day, my lord, division bench judgment, this honorable bench judgment was also shown to me. I have also gone through. There, my lord, have said also you constitute a common cadre.
Yes.
That was the direction. Judgment. Yes,
Yes.
this honorable bench. Yes, this honorable bench has passed that order.
My lord, sir, directed to constitute the cadre and state also submitted that.
It is being done.
That is a small order, my lord. Maybe I have not gone through that. But this is the spirit of that order. This bench has passed that order. So everything, my lord, at a stage when the cadre has not yet been finally constituted. So unless a cadre is constituted, the transfer is not permissible as per rule, this inter-transfer to rule of 79.
Your lordship may grant me some time that I will be in a position to take complete instruction as to whether that cadre rule has already been finalized or not.
It has not been finalized. Cadre rule, no.
Gradation list. My instruction is, my lord, there is a provisional gradation, tentative gradation is published, sent for objection to the teachers.
Seeking objections.
That has not been finalized. And my lord, there will be another problem, my lord. There will be a legal problem because we are doing these cases. My lord, the now cadre, section 10C says the government can formulate cadre for different groups of teachers also. In the Odisha, there are two type of teachers. One is getting full salary cost under the direct payment scheme. Other groups are like this case, they are getting block grant. So now, they cannot be equated together. That is why what they have, I have seen that tentative gradation list. This is for the aided staff. Full receive, they are getting full salary cost from the government. They are in that cadre list. This type of institution has not yet been brought into. Rather, when we are filing cases of the aided institution, this type of block grant institution, their government consistent stand is, you are not governed under that 1974 rule. That is why a judgment in Vaijayanti Naik case of the Honorable Single Judge was passed. No. 1974 rules, since it is declared to be an aided institution under Section 3B of the Act, there the application of this rule are universally applicable to all category of institutions. But against that judgment, a writ appeal is pending. So these are the peculiarity in that case. But so far the block grant institution, my lord, there is no CAD as on today, neither tentative. So now in this type of institution, since the my response submission in this particular case is, since the Premalata Rao case is not under challenge in this case, Premalata Rao, following the Premalata Rao, this honorable court has.
Mr. Mishra, forget everything, whatever. See, this is this is a college. We have to decide who is the senior most. We can apply the principles of seniority, clear principles of seniority. And if that principle of seniority is followed and the senior most is to be appointed, then he shall continue. What is wrong in it?
Yes, my lord. My lord, may hear it finally. This the only point is, my lord, fact is undisputed fact.
I'll be ready.
Both of them joined in one day, 12-10. I am senior in age.
I'm ready, ma'am.
Only that is the point, my lord. A small point.
Seniority is it's not a complex issue.
He is not.
So in fact, we don't know how much time will it take for them to finalize the gradation list. And in the meanwhile, keeping this ad hoc arrangement of giving dual charge or bringing someone on transfer, violating the provisions of the rules, why should it happen? If there is any dispute of seniority in a college, then that will have to be resolved by some authority or by the court.
Yes. Previously, one case, my honorable judge, Mr. Ratta has argued that case. ASS college, whether the plus 2 college principal, which is a fully aided, has been directed to function as the principal of the plus 3 college, which is a block grant institution. That was resolved by the honorable single judge. Matter went up to Supreme Court also. That has been confirmed. My lord knows that judgment. I was assisting. No, I argued because you have left the court giving the file. So there also the law has been settled.
We can list this matter. We have heard learned counsel for the petitioner, learned counsel for opposite party number 4, and learned AGA for the state. So list this matter on 2 weeks.
Next week.
2 weeks.
Well,
2 weeks.
19th. 19th will do.
On the 19th. Right. The next date, we will consider the question of determination of inter se seniority amongst the teachers of aided colleges. Aided college?
Yes, college.
Aided colleges.
And higher secondary school. This is a higher secondary school. Plus 2.
Aided colleges / higher secondary schools. Privately managed, aided. These are privately managed.
Yes. Aided means that.
Yes. So that will be the question.
My lord,
so that no such controversy.
Further litigation.
Yes.
Maybe. Lord, in fact, this is a contract in pertinent to Annexure 1, Lordship, is the tender notification dated 30th January 2024, Lordship. And Lordship, page 17,
I had participated for in respect of item number 1. Lordship. And Lordship, kindly see, as per the eligibility criteria, I qualified, and technically they qualified me under annexure. Lordship 2, page 41, Lordship, kindly see. On 22/2024, after making due technical qualification evaluation, Lordship, they qualified me. My name appears at serial number 2. Jayaprakash Sharma, Lordship, kindly the qualified and disqualified column. I became qualified, Lordship. Then Lordship, kindly come to next page, page 42. Improve this technicality, Lordship, qualification. They opened my price bid also, Lordship. I become the lowest bidder, Lordship, page 42. Then Lordship, kindly come to annexure 4. This is the cause of action I approve, Lordship. Without any knowledge of the petitioner and without any intimation, Lordship, after opening a price bid, again they declared, Lordship, they come up with second technical evaluation and they disqualified me, Lordship. On 9/3/2020, Lordship, that is on, they have 9/3/2024, and they're relying upon the same technical evaluation, Lordship, they have disqualified. This is the cause of action I approve, Lordship.
Yeah.
Lordship had to protect me. And now, Lordship, in the meantime, they have filed their counter. In counter, they are saying, Lordship, kindly see, just I'm relying some documents.
No, you are referring to annexure 4.
Annexure 4, Lordship. This is cause of action.
Reason for disqualification is what?
No, Lordship. Reason they're saying, Lordship, kindly see, disqualify 4 as per letter number 10586, dated 9/3/2024.
Where is that?
Which is, Lordship, that is much after the.
No, where is that? 9/3/2024.
That is page 97, Lordship, kindly see. They have annexed in their counter. They disclosed in their counter, Lordship, that is page 97.
Page 90?
97, Lordship. Running page, Lordship, I have paginated 97. 97.
What is there?
Lordship, they have come up with the second technical evaluation after opening a price bid. Lordship, kindly come to, on the complaint petition received by the opponents, Lordship, they have filed some complaint that I have some ongoing contracts, Lordship, and I have not disclosed in my tender. That's why, Lordship, they have come up with a second disqualification, and by making a decision-making process without knowledge of mine, Lordship. They have not intimated me, I don't have any knowledge. And then, Lordship, kindly say 9th, they have come up with a notification. Then, Lordship, kindly
So whether you had disclosed or not,
Lordship,
about your pending commitments.
Lordship, that was as per contract, Lordship, as I have disclosed as per the requirement under law. So, Lordship, had it been
law or under the tender documents?
Under the contract, Lordship. Under the contract, Lordship, that requires for a, sorry. No, as per contract means, Lordship, advertisement terms of contract, Lordship. Terms of contract, Lordship. Because the terms of contract says so, disclose for bid capacity. Bid capacity, Lordship, is a.
No, where was the requirement under the tender notice that you were required to disclose your pending commitment?
Lordship, I have disclosed, Lordship. I have disclosed.
Where is that?
Lordship, that is
where is that requirement?
That, Lordship, that requirement, Lordship, that is page 23, Lordship. Page 23. Lordship, Lordship, got page 23.
Yes.
Lordship, clause 8, Lordship, that is bid capacity.
Yes.
Bid capacity as per Works Department letter number 6300 dated 16/6/2011. Bid capacity clauses as qualification criteria has been included. This stipulation shall be applied to all works above rupees 3 crores. Applicants who met the minimum qualification criteria will be qualified only if their available bid capacity at the expected time of bidding is more than.
See, we have seen this. the statement showing value of existing commitment
Lordship,
and ongoing works,
Lordship,
as well as stipulated period of so and so, whether this was disclosed by you.
yes,
or
Lordship, that they have annexed, Lordship. Lordship, kindly see that they have disclosed, they have annexed and they have qualified, Lordship. Kindly come to, it starts from page 65.
no,
They-
whether any work was concealed by you, any pending commitment.
Lordship, I have given the entire list, Lordship.
Entire.
But I have given the entire list, and after due qualification, they have qualified me, Lordship. But now, Lordship, if somebody makes a complaint,
No.
Lordship,
Complaint, if complaint is untrue, it is all right.
Lordship,
But if they found some truth in the complaint, that
Definitely.
means the documents which you have given, something was wrong in that?
no, that they are saying nothing wrong, Lordship. They
Yeah.
are saying I have not given a particular work, name of the particular work.
Yes, so
That is their allegation. I have given all the particular, I am qualified, Lordship. But they are saying you have not given a particular work which is given after commencement of this tender process, Lordship.
let us,
After commencement of this
let
tender
us see that
process,
then. All right.
let's say they are saying this tender process, Lordship, they are saying.
So that means on the date last date of submission of bid, that document you could not have given.
Lordship. Because in fact, that's Lordship, if Lordship.
What was the last date?
Last date, Lordship, that is. Last date, Lordship, is 16/2.
Okay.
16/2?
16/2/2024.
You have submitted your bid on bid when?
Lordship, within that stipulated period, Lordship.
Okay.
No, when?
That particular date I have not given, but that is appearance, Lordship, page 62.
That is material.
Okay, let us consider 16/2 then.
Lordship.
All right.
16/2, Lordship.
Yes.
Lordship, can you consider 16/2, Lordship, last date I have given. But Lordship, I want to draw Lordship, can attend Lordship, can page to 106. If it is back then, this rate petition for us become infructuous. 106, Lordship, can their own admission. They are saying, please 106, Lordship, kindly see.
This has become infructuous.
Lordship, please 106, Lordship, kindly come, page 106. If that is so, they page 106, Lordship.
They have cancelled the entire.
Lordship, they are saying the tender validity up to 16/5/2024. Lordship, page 106. If that's true, Lordship, then nothing to be decided. It is, Lordship, amounts to kills courts, honorable courts, valuable time, Lordship. And page 106, Lordship, kindly see.
Should have withdrawn in June.
No, I am not written. They are saying, Lordship, while alive, Lordship, they are saying the tender is valid up to 16/5/2024. On Lordship, 14/3, they are saying final evaluation, so 16/3.
But isn't there a clause for validation?
Validation for 190 days, Lordship, to 120 days. That has already been expired. Because tender of Lordship 31/2024. In the meantime, Lordship, more than 2 years, around 2 years, Lordship, going to be expired by this date, Lordship. And so that's why by Lordship, by disqualifying me, see 31/2024, Lordship, date of tender.
31, yes.
31/24.
Yes, work.
1/2024.
Yes.
Now, Lordship, is it 11, Lordship?
Yes.
2020.
Yes.
Why are you saying this 2 years?
No, sorry, 1 year, Lordship. Sorry.
Yes.
1 year,
Not,
Lordship. 1 year. Then validity is 120 days, Lordship. 120 days is tender. OPD code speaks of maximum 120 date of notification. Now they have 106, Lordship, kindly see. While giving this final evaluation, excluding me, they have, Lordship, by dividing me, they are saying the page item 28, the tender is valid up to only 16/5/2024. So in time, Lordship, in the meantime, more than.
So they have recommended the case of Mr. Malay Kumar
More, but in the meantime, while allowing him, they are saying it is only valid up to 16/5/2024.
Provided Mr. Mund has not extended his.
It cannot be, Lordship. Subject, they will accept that, Lordship. They will take a decision whether it has to be extended or not. Because, Lordship, unnecessary, the escalation clause will come to play if they will say.
This letter was dated 19/3.
19/3. No, this is tender evaluation of that is 14/3, Lordship. 14/3/2024.
Looked like 19, so I said.
Lordship.
All right, so 14/3 letter.
They have handwritten, that's all, makes confusion. 14/3. So here, Lordship, they are coming with. So this is the Lordship coming on the. If they say that they will go for the tender, then I will argue, Lordship. Otherwise, my humble submission, Lordship, this entire action is lacks competency, Lordship.
So let us see which work was not disclosed by you according to them.
Lordship, they are saying, Lordship, that is a Lordship, kindly see that evaluation itself that is there. And Lordship, that is on page 97, the bid evaluation they have made, Lordship, that is on 9/3/2024. Lordship, they have given that finding clause 21, Lordship.
Yes.
Technical bid evaluation committee was held under the chairmanship of Chief Construction Engineer, Circle Bhanipatna. The committee qualified 4 number of party bidders. For opening of the price bid cover 2 technical bid of 4 numbers of bidders were found to in order to accept 1 no bidder Utkal Kumar Sharma A contractor has been disqualified due to as per Bhubaneswar. Then Lordship, kindly come to next page, Lordship.
Mr. Have you gone through? The details are not given. What you have suppressed is not there.
No, next page that is there, Lordship. Grievance if any, Lordship.
Check.
Page 99, Lordship.
Exact details are not there. Only the complaint letter is there.
Next page.
All right. See.
Next page, Lordship, they are saying that one Malamundu made a complaint.
What is the complaint? What is the work? That is not there.
That is not there, Lordship.
Exactly. So what is the complaint that we want to see?
So that Lordship, kindly see that they have annexed in the page 88, Lordship.
No, what is the finding of the technical committee?
They are
on
saying,
the
Lordship,
complaint?
Lordship, they are saying because I have not.
Where is that?
They are saying, Lordship, on 12/1/2024 there is a contract.
26. 26. Item 26. I was reading item 21. Huh?
21 he was pointing out findings of that was initial.
No.
That was the initial. Just a-
90 page number.
Okay.
Correct है ना?
Anisha
Brief
3.
तो correct है ना?
Anisha 3. Anisha J by 3.
By this series,
Page 99. Yes, grievance if any.
Complaint. Satisfying that suppression.
What is the finding?
Finding, Lord, they saying I had a contract. I have executed an agreement on 12/1/2024. That's why, Lordship, that has not been disclosed. That's why they have rejected my.
So, Mr. Dale,
Lordship.
12/1 is before last date of the contract. The
Lordship?
last date of 12/1.
That they are disclosing, Lordship.
No. They are disclosing. You are saying it is incorrect. You have not executed
But Lordship,
anything.
I can explain that, Lordship. I can explain that, Lordship. My humble sir here, Lordship, had it been a case, Lordship, I could have been noticed because once you have already opened my technical bid and opened my price bid, and Lordship can say most people at the case, Lordship can come to page 41. That is very important, Lordship.
We will see that.
Lordship.
But this is a fact that you had not disclosed.
That is there, Lordship.
That's all.
That is there. But Lordship, can you come to page 41? Page 41, Lordship, kindly see.
That's right.
But there is explanation, Lordship, because of what they did, Lordship. In fact, Lordship, due to COVID, Lordship, when the contract has already been floated, they are taking, because I became qualified, they are in advance, they are taking the entire papers along with the agreement by the authorities but they are putting that dates. That is never knowledge of the petitioner because it makes no difference to me, Lordship, for qualification. Only it is an information to the authorities as per the terms of the contract. So, Lordship, kindly come to page 41 for a moment. Page 41 for a moment, Lordship. While Lordship qualifying me, there is a condition. A minimum time period of 5 days will be allowed to receive grievance, allegations. So, Lordship, this forum was available on 17/2/2024, Lordship, to all the bidders to file their grievance within 5 days. They did not do the, Lordship, that.
Mr. Dale,
Lordship.
it is minimum period.
Minimum period, Lordship, 5 days. So, Lordship, it
At least 5 days.
at least 5 days. Lordship, it stops, Lordship, after opening a financial bid. Lordship, this forum is available, Lordship, that is available to everybody. But before opening of the price bid, if Lordship, if once opening of price bid,
See, we are of the view
Lordship.
that even after finalization of tender in someone's
Lordship.
favor, it is found
Lordship.
that some fact was concealed which was required to be
Lordship,
disclosed,
grateful
that
Lordship.
can be cancelled.
Lordship, that is my submission, Lordship. My humble submission before Lordship. Can they come up with what expansion? Lordship, kindly, that clause is available itself, Lordship. Kindly come to. Lordship, kindly come to eligibility criteria. That clause is very much available, Lordship. I don't dispute to that.
That is not the question, Mr. Question is, you were required to disclose something which you did not disclose. That's the only thing. Why should we?
No, Lordship. My humble submission before Lordship. It as per Lordship, they have disqualified me as per the terms of the contract, Lordship. So when the
Why are you saying contract?
advertisement, Lordship? Contract means I'm saying terms of advertisement, Lordship. Terms of advertisement because it, Lordship, the entire conditions come under the detention clause.
Yes.
Manoj, may I please your words?
You are for
I
whom?
am for the opposite partner, 5 months. The work has been awarded to me.
Yes, what is your stand?
Well, page 6 of
What
my,
is the stage of the tender process?
it's not,
Yes, my lord.
Interim
order.
interim order is there. it's
Interim
not
order that is not been extended, Lordship, by last occasion because Lordship.
At page 6 of my counter towards the bottom, Millard, I have already stated that what suppressions they have made. Along with that, Lordship, kindly have a glance to page 53 of my
All right, is that your summation is over?
Lordship, no, two further arguments are there, Lordship. Lordship. Only they have come up with a plea, Lordship, because they, Lordship, evaluated my bid, Lordship, by the competent authority. Now, they have come up with the final conclusion with third round of technical evaluation, which is never permissible under the terms of advertising or under the OPW code, Lordship. Rather, OPW code prescribes, Lordship, as per they have given the reference, as per the clause 3, the engineer chief can finalize the tender. He cannot evaluate, Lordship. You, Lordship, kindly see. On the first date, they make evaluation on 22/2024.
No, whether this fact is admitted or not,
No.
that you were required to disclose and you had not disclosed.
Lordship, that
We are exercising writ jurisdiction.
Lordship-
We will not go into.
no, I'm on that. I'm on that only, Lordship. Had it been a case, I could have, Lordship, they could have been provided with a reasonable opportunity hearing. Lordship, I could have been answered, Lordship. They have not done this. They have, Lordship. That's why, Lordship, I file a rejoinder, Lordship, because that fact should come, Lordship. That fact should, Lordship. I told the fact, Lordship, because Lordship, during COVID period,
So you file rejoinder.
Lordship, if Lordship,
You
because
want to file rejoinder.
rejoinder, Lordship,
File it.
Lordship, file a small rejoinder, Lordship, because I want to,
Do it. How much time?
Lordship, as a Lordship, is
Wait, no.
because Lordship, the impression was, Lordship, it come on 2 o'clock, but it has come up on 29. That was our understanding.
All right.
Because we
As
got
requested on
Lordship,
behalf of the petitioner,
impression
this is
2 o'clock. That's why.
4 weeks, so as to enable him to file a rejoinder to the counter affidavit which has been filed on behalf of the opposite parties.
But the
To
date,
make
Lordship.
it clear that the pendency of the present rate application shall not come in way of the opposite party proceeding with the tender process in question. Yes.
No, Lordship. Because Lordship, kindly Lordship, consider my submission. Our impression on both
No,
sides.
file rejoinder.
But Lordship, because Lordship, kindly Lordship, don't take it otherwise, Lordship, my submission. Because we had impression, Lordship, matter
All right,
taken.
when will you file your rejoinder?
3 days, Lordship, I can file.
3 days. All right.
I
3
can
days,
file
sir.
by 3 days, Lordship. Because
3 days.
impression was
All
on
right.
taken on 12, Lordship, the 2 o'clock. Lordship, dictated order, it taken 12 by, on 12 at 2 o'clock. But it came up on, in advance, it has come, Lordship.
All right.
So that
So we are
both
keeping,
are confused.
we are keeping
Night.
to 12th, you file your rejoinder by 7th. All right?
Lordship, by
All right.
12 2 p.m. Yes.
12 2 p.m. Lordship, it can, because it was understanding,
Last
Lordship.
occasion, my lord, that my vacation
No,
of interim
this,
order petition
the
is there.
pendency
my
of the
lord.
writ petition
Yes,
will
my
not
lord.
come
that
in
is your
way
worship.
of the opposite parties proceeding with the tender process in question. Yes.
Lordship, if that is
Item
so,
of-
then Lordship pass any order that otherwise why it will be pending, Lordship. Because I draw Lordship kind attention, page 106. If that is so, then can proceed, Lordship. Page 106, Lordship. That's why the Lordship outset I
Mr.
draw-
Kanai,
Lordship.
you are testing our patience.
No, Lordship. Never, Lordship.
1. And 2, finally, whether short or long, the orders are to be dictated by us. One
If-
order has been dictated.
That's why, Lordship, closing my submission. Lordship, pass any order. Lordship, I am I don't want to linger this proceeding, Lordship.
All right. So you will not file any rejoinder.
No, Lordship. Your Lordship, pass any. I don't mind, Lordship.
Don't mind.
No, I will not file, Lordship. Regenter. Your Lordship, pass any order.
Reserve.
Lordship. Only my submission, Lordship, that Lordship, my submission of the competency only, Lordship, can you consider.
To give your learned counsel for the
Huh,
petitioner, so states that he shall be filing a written notes of arguments.
Lordship.
Stop. Let that be done by
Lordship, any date, Lordship.
Friday?
Friday, Lordship.
Friday. Stop. Over the pendency of the writ application will not come in way of the opposite parties proceeding with the tender process and questions. Yes.
Grateful. Item number 4.
Page order that
May I pray only Lordship, I do not have written note, Lordship, pass any order, Lordship, that my written note we can linger the proceeding also, Lordship. Lordship, pass. I will not file written note, Lordship. Lordship.
Item 4.
In this case, my,
please,
we have received the instruction, my lord. Today, we'll file the counter affidavit by next week. 2 weeks time we grant.
Let the affidavit be filed.
your lordship passed an order on 22nd, and on that aspect, to file the counter affidavit.
I'm praying for 2 weeks time. We will file it with effect. Because today I have received the instruction.
How much time?
2 weeks time.
2 weeks time is allowed for the opposite parties to file counter affidavit. What is the last?
Okay.
Last order, it is that matter where that
Another
debar thing had been recalled. So we had said from so and so. That has not come.
File it. It's a peculiar case where is debarment order has been recalled.
Yes, ma'am, that is the fact.
The court had made an observation that that shall not be treated to be a stigma, and still you are.
Today I got the instruction.
2 weeks.
That's my grant 1 week time. 1 week time.
1 week. 1 week. The time is allowed for the state to file counter affidavit.
One matter, has it been left out?
Another, the tag matter, in this matter, the interim order is there. Item. That is 19492. 2 matters are tagged by 19492 of 2000.
The interim order passed in 19492 of 2024 shall continue in the meanwhile.
Any dates will be kindly fixed. Your lordship fixed any date.
1 week.
Not on 13th, my lord, I have personal difficulty.
12. Please serve copy of the counter before that.
Press admission item number 6. May I please, my lords. This writ appeal has been preferred against the order passed by the Honorable Single Judge. Your lordship will find the order at page 43 of the brief. There, the Honorable Single Judge at para 4.2 of the impugned order has taken note of a judgment. This third line of the para 4.2. This court filed its judgment dated 12/5/2000 while upholding the judgment passed by the tribunal on 13/12/1996 made the following clarifications. First one is important. The state government is required to terminate the appointment of all those persons as per primary school teacher whose merit position in 1991 panel doesn't justify such appointment. If necessary, the state government may give the individual employee an opportunity of placing his documents before terminating the employment of individual employee on basis of tribunal's order dated 13/12/1996. That has been acted upon. But while doing so, since no notice was given to the person concerned, it has been held to be illegal, and that writ application has been accordingly disposed of. Your Lordship will find the direction, page 46, para 6. Page 46. May I please, my lord? Having heard learned counsel appearing for the parties and after going through the materials available on record, it is found that the absorption of the petitioner as regular prime security chair and of similarly situated Sikha Karmis were challenged before the tribunal batch of application. The tribunal, by so and so, directed that those who are illegally absorbed will be disengaged from their work. The said order was challenged before the Honorable Court and batch of written. This court, by its judgment dated 12/5/2000, though upheld the order passed by the tribunal, but issued certain clarifications. The clarifications issued by this court in para 8(1) clearly speaks that prior to such termination, the concerned employee is required to be given an opportunity of hearing in order to enable him to place his document. Since from the counter it is found that no opportunity of hearing was ever given to the petitioner in terms of the order passed by this court, it is the view of the court that the impugned order of termination is not sustainable in the eyes of law.
Yes, who is for the other side?
Sorry, man.
Who is appearing for the?
I am for the respondent one, man. Respondent one. On last date, my lord, my lord directed me to obtain instruction, though I took time, my lord, I already filed an affidavit in order to show that how many persons did not join up to the serial number 139 the petitioners since respondent number
Mr. Counsel, the entire process was found to be bad. And have you filed your affidavit?
My lord.
Huh?
My lord.
Let us see. Where is that affidavit? When did you file your affidavit?
My lord, flag Z, my lord, flag Z.
When did you file?
On 9th of October, my lord.
So the direction was to file an affidavit stating as to how many persons above you were not appointed.
Not appointed.
Where is that?
My lord. May I some?
So are there persons
My lord.
who were above in the merit list but were not appointed?
My lord.
There are persons.
My lord.
Then the entire
My lord, may I submit one?
Yes.
Subject to my lord. My lord, up to one petition, there are 106 of the UR category post. Respondent number 1 belongs to UR category. Yeah, out up to 139 position, the respondent 1 having total 88% they did not join. In first phase, my lord,
they did not join or they were not appointed.
They did not, my lord. This is a panel list of Sikha Karmi. Out of this panel list, they are to call for verification.
Mr. Counsel, the whole panel has the exercise has been found to be illegal by this court. There is a specific finding. What more is required? What more?
I'm just saying, my lord, one thing, my lord, because I admit that my position is 139. Up to 106, since you are post there, the authority called up to 75% to submit for verification their records. Out of my 75 persons, 34% joined and 41% they did not submit their records, my lord. So 34% allowed to continue. Again.
Sir, the question is that the entire merit list was found to be, entire selection process was found to be illegal. That has been found to be illegal. Now the question was whether before or issuance of termination order you were required to be given an opportunity of hearing. And the entire process has been found to be illegal. Then what hearing?
Only submission because the last of the matter directed to prepare that list I have given. And another submission, the persons subject to the persons below to the serial.
That is the problem.
They are also.
That is the problem, that the persons who were below you, they have been appointed. But the persons who were above you, they were not appointed.
Because they
therefore, the court says that it was a pick and choose.
So I am coming within 106 position. My position, I will kindly see for a moment the affidavit. I'm coming within 106. 106 is meant for the UR category. Since my lord 58% they called twice and they did not submit their verification.
The whole appointment has been found to be, the entire exercise has been found to be illegal.
That is
Allowed.
my
Allowed liquor.
Item 7.
Yes.
Yes, sir.
My lord, tools, counter file.
Counter
File.
file. Counter file means you will file counter affidavit, or you have filed counter affidavit, or
Counter in the writ appeal.
you will file counter affidavit in writ appeal. Why? Yes, what is the what is this matter about?
Well, the petitioner was found to have indulged in a criminal involvement in criminal proceeding. That is how he was terminated. He says the Honorable Single Judge rendered a judgment wherein the Honorable Single Judge came to a conclusion that mere initiation of a criminal proceeding will not be sufficient to terminate somebody. My lord, your lordship will find at page 26 of the impugned order, the para 6 towards the last portion. The question is whether mere involvement in a criminal case can be treated as a misconduct in employment. This court, in the case of Rajiv Lochan Biswal versus State of Odisha and others, reported in so and so, held that mere involvement in a criminal case cannot be treated as proof of guilt. Similar view was taken by this court in the case of so and so. Even otherwise, it is not legally conceivable that a mere allegation of an employee would be visited with punitive action for misconduct. This court is therefore not inclined to accept the contention advanced on behalf of the state that merely because the petitioner was involved in a criminal case doesn't automatically make him guilty of the said offence until and unless the same is proved in a competent court of law. And finally, my lord, para 7, even otherwise, this court finds that by letter so and so, the district project coordinator asked the petitioner so cause as to why he shall not be disengaged from service for such long unauthorized absence in his duty from 15th October.
So what is that? This 5/1/2019.10.5?
10.5. I'm coming to that, my lord. 10.
Quoted in page 28. So it has been quoted.
28.
Running page. Internal page 8 of the order.
10.5
is quoted.
Content, yes, madam. It has been quoted at page 10. The engagement will be on annual contract basis. Contract will be renewed in subsequent years depending on the performance of the candidates. Prior to renewal of the contract, the junior teacher has to obtain a certificate from the concerned headmaster and the school management committee regarding his or her regular attendance and satisfied service, which is produced before the level. The junior teacher can be disengaged from the service with the prior notice 30 days if he violates the condition of contract on the basis of adverse report on the case with unauthorized absence, misconduct, involvement in a criminal case. That is in terms of an agreement, my lord.
This order does not require interference. See, the simple fact is that a criminal case was lodged against him.
Yes, I understand that.
He was arrested. He was in custody. He did not inform that he is in custody.
Because he was inside the bar.
Then after, he might have attempted to conceal that also.
Only thing is, only in the agreement, which is available at page 102, in the agreement there is a clause. Your lordship will find.
And that was report of the BEO. That one, 10.5.
No.
Another one.
16, page 104, a part of annexure 5. 16, clause 16. Available at page 104. This is an agreement between the petitioner and government. that the second party has agreed to serve in the manner as required and perform the duties assigned by the first party, and he or she has agreed to be disengaged without any notice on ground of involvement in a criminal case, misconduct, delinquency, incapacitation, unauthorized absence. This is the only thing I can place. Now,
Compelling him to agree to such. That's not good. This can be the
You're not interested.
your lordship wanted to see 10.5. If your
Yes,
lordship
sir.
wants to see 10.5, it is also available at page 79.
Similar clause.
Yes, yes.
We are not interfering. Dismissed.
Item 8.
Challenge the order of ordinance single judge directing to consider the case of respondent for rehabilitation avenue. And the sole question involved in here, by the time the application was considered, 2020 rule was enforced. But he took the view that in the 1990 rule will be applicable. But in the case of Anup Kumar Senapati case, Apex Court has held, by the time of the consideration of the case, the rule that is enforced, that it do apply. So
Yes, so
it needs
this has been decided by this court also. Following Senapati.
Bindusagar Samantara case is pending, my lords.
Huh?
Before the Honorable Apex Court, Bindusagar Samantara's case is pending, my lords. The state had approached the Honorable Apex Court, my lords. And my lords, the respondent's father died in the year 2017. We applied in the year 2018.
Just one minute. Bindusagar Samantara has been challenged by the state.
Yes.
Do we have the orders of Bindusagar?
Give a printout.
Anup Kumar Senapati versus state, that has been decided. They say that by the time we are that judgment has now out.
Right now, you don't have the judgment.
Let it come.
Let us see what Anup Senapati is.
So I will supply the judgment, let it come day after tomorrow.
All right, as requested.
We also
On
bring
behalf
water
of the
for
appellants, is this matter on? Monday.
Item 9.
Anukumar Senapati is granted aid.
Hello?
Anukumar Senapati is granted aid.
No, here in the appellate memo or here, I will say to it.
What will you say?
Repealed law, right? Got it.
One cannot take the benefit of a repeal rule which is not in force at the time of consideration. That is the principle decided.
No,
Because
see,
22 rules.
the date of death is definite. The date of birth may also be definite. Date of application may be definite. But your date of consideration is indefinite.
Yes, ma'am.
So if today application is made, you can decide the application 5 years thereafter. No one knows. In the meanwhile,
Application is relevant.
so the date of application is
Will be relevant for consideration.
Not date of death may not be, but
No.
date of application should be.
Date of application.
Because you will
Date of
decide whenever you
application,
feel like, why should
he
you
has
suffer?
filed before 1920 rule came into force. That is
so
it.
there are certain
ma'am.
things, like for the purpose of determination of someone's rights, the date of application is very important. But for date of consideration, particularly when you don't have any fixed time for consideration, then
And the Honorable Single Judge has only passed the order to consider the case. Whether he has taken decision or not, the authority, that is not on record. So,
That you have challenged, you should say whether it has been
yes,
taken or not.
that has been challenged, but not during our time, previously it's challenged.
Monday.
Tuesday.
Tuesday.
I'll agree with you that the council can-
Yes.
Item 9. 9, my lord. Your lordship will find. Your lordship will find the impugned order at page 80, annexure 4, my lord. I'll invite your lordship's attention to para 4.1. Sorry.
I'm suggesting.
Should I continue? Page 81, next page, about 4 lines from the top. Second line from the top. This court might order this so and so disposed of the matter with the direction on the opposite part number 3 to take a decision on the claim of the petitioner pursuant to the said direction. Opposite part number 3, while considering the claim, rejected the petitioner's application on the ground that retired employee since was appointed under the triple benefit scheme 1966 as per notification issued by the department on 8/3/18 and subsequent clarification issued on 1/5/2018, petitioner being an unmarried daughter of the deceased pensioner is not eligible to get the benefit. And after that, para 6, in that page last portion, having heard learned counsel for the parties and considering the submissions made, this court, while disposing of the writ petition, is inclined to quash Office Order 31/2023 under Annexure 10. While quashing the same, this court directs opposite part number 2 to 4 to sanction the family pension as due and admissible in favor of the petitioner. We have assailed this on the ground that this is not.
So where is this order?
Sorry.
WPC 1313241 of 2020.
13241.
That is my lord, page 75.
Yes.
In the appeal. That
Page
is, my lord,
75.
Starts from page 60.
No, it starts from
page
page
60, operating is page 75. 78, my lord. Operating, 78. The lordship decided that it is being a social security measure, family pension to unmarried daughter. So that should the notification issued by the resolution passed by the government is not in constitutional law, and accordingly quashed it as actual payment for pension benefits. That are not challenged by before any other forum matter. Higher forum. Accordingly, they also considered in my case that this is covered by that judgment. Accordingly, I single passed the order. That are never challenged. And in the writ also, they are nowhere mentioned that that order has been challenged by any other forum.
It has not been mentioned.
Nothing
But
mentioned.
in the writ appeal, we have said that
Nothing is mentioned.
relying on the circulars, the order has been passed. Those circulars have never been challenged. His case was not considered by the authority concerned. Sorry.
But if in that decision, court has held that the resolution
That
is
is
not
correct.
correct, then
That is correct. Court has held it. That is correct.
otherwise also it is a beneficial provision.
That region, my lord said. Family pension to unmarried daughter have to for survival.
The ground we have taken in para C, available at page 8 of the brief. Para C. Further, the writ petition is not maintainable on the ground that both the impugned orders under Annexure 8 and 9 to the writ petition, wherein the rejection of the claim of the respondent has relied upon School and Mass Education Department notification number so and so 8/3/18 and order number so and so 1/5/2018. In the said order, the BEO has relied upon the above said notification while rejecting the claim of the respondent for grant of pension to the unmarried daughter. But it can be very well seen that the respondent has not challenged those notifications basing upon which the BEO and the Accountant General Appeal number 3 and 4 has rejected the claim of the applicant.
We will keep the legal question open, but since there is no legality in the order, and learned single judge just followed, that was binding on the learned single judge. Question whether an unmarried daughter shall be entitled to family pension or not, that can be decided in
Yes.
appropriate proceeding, but
Appropriate.
not here.
Correct.
So that also WPC 13241 was a decision of a learned single judge or
Single judge.
Single judge.
Honorable single judge.
page?
Single judgment.
Page 65, my lord.
That is there.
That is there. The one next. Page starts from page 60, page 60, sorry, page 60. Cuts. Operating page 78.
Yes. Starts from page 60.
The state of Odisha in the present intra-court appeal has put to challenge an order dated 26/2/2024 passed by a learned single judge of this court in WPC number 4623 of 2023, whereby, following decision rendered by a single bench of this court in dated 23/12/2022 in WPC number 13241 of 2021 has held the respondent entitled to family pension, C being an unmarried daughter of
This is primary school teacher.
of primary school teacher
Yes.
of a primary school teacher. So stop. Next, the respondent's claim was rejected on the ground that the respondent's father was covered by triple benefit scheme,
My lord, TBS.
bracketed TBS, and therefore she was not entitled to such benefit. So stop. Next, learn AGA appearing on behalf of the appellant has submitted that in terms of the executive instructions issued, issued since the petitioner's father, respondent's father was had opted to be under triple benefit scheme, the respondent was not entitled to family pension. So he has submitted that that unmarried daughters of a primary school teacher covered by triple benefit schemes is not entitled to a family pension. So stop. He has, however, not disputed the fact that a single bench of this court in case of Puspalata Sarangi, bracketed Supra, after having taken into account the provisions of law and government notifications has held that has held in paragraph 34 as under. Full stop. Kelly. Has held. Where is the opinion recorded?
It is when page 32, sorry, page 74, paragraph 32. 32, my lord. Paragraph 32 and 33. They have discussed everything and thereafter passed the order. The notification they have relied upon, that is also discussed at yes, page 70. Para 18, the same time taken notification under 1/5/2018. That is also discussed in that order, paragraph 18, page 69.
No, where this has been laid down, it has been held that.
That is my lord, page 76, paragraph 30 also they have decided. Extra employee, extra prime minister is also entitled for benefit. Paragraph 30, page 76. Extra employee, thereafter, page para 31, triple benefit scheme. That one discussed.
So it is not denied that it is unmarried daughter above 25 years is eligible for family pension, but in this case they are disputing because the father was getting TBS.
TBS. That is the decided in that case. That again
Because of that.
that decided that.
What is specifically laid down? Yeah, look. As held an unmarried daughter of a retired primary teacher covered by TBS triple benefit scheme to be entitled to family pension. So stop. Learned single judge has, in our opinion, learned single judge, the decision of the learned single judge cannot be said to be legally infirm, as he has followed the observations made by a decision made in the decision rendered in case of so and so, which was never put to challenge by the state. So stop. In such circumstance, we are not inclined to interfere with the impugned order. So stop. For the present, we have not gone into the correctness of the decision on the point as to whether an unmarried daughter of a primary teacher covered by triple benefit scheme shall be entitled to family pension or not. So stop. The said legal question is left open.
Okay.
So stop. We have not gone into the said question. In the present facts and circumstances, we have not gone into the said question. Yes.
Item number 10.
I don't know what to pay. Copy of the appeal memo. In course of the day, I am serving. Unfortunately, I have not served. Last year, kindly call this matter along with WA number 1831 of 24. That a connected matter. On same day, it has been disposed of.
Like number 10. Let a copy of the writ appeal be served upon
Respondent.
respondent.
Sorry, respondent number 3.
What is your name?
So
and so. Appearing for respondent number 3 in course of the day.
Yes, sir.
Oh, stop. Which is this other writ appeal?
That WA number 1831 of 2024.
List this appeal along with WA 1831 of 2024, in which the same order of the learned single judge, which is under challenge in the present appeal,
You are appearing.
is
in
under
that.
challenge. On date has 4 weeks. Therefore, this is being listed and that will exist.
Not admitted yet. The lawsuit may keep some earlier lawsuits that it has started.
4 weeks. Prior to 4 weeks. Why? Is there any urgency?
Yes, sir.
Question.
Hello.
Two weeks.
Item 11. Quickly, the point is,
My lord, I'm seeking a passover on behalf of the respondent. Passover on behalf
it's a
of the
fresh matter.
Mention beforehand.
It's a fresh matter. I don't mind.
Tomorrow.
Tomorrow. Item 12.
The limited grievance before my lord is this, the honorable single judge, while directing to pay the gratuity, directed to pay 12% interest. And the next point is when the category there is no provision for appointment of rehabilitation ground, my lord, only monetary compensation. Then the honorable single judge says you consider it for his appointment. This is the 2 points, my lord.
Second point is no point.
Yes, my lord.
Because you have to consider.
Consider, yes, my lord.
So what about
This is your. We say that, my lord, your lordship may turn to. I'm only citing one provision. That is Orissa Civil Service Pension Rules 1992, Rule 49, my lord. Rule 5, sub-rule 5, where the sanction of payment of gratuity is delayed for more than a year from the date in due under sub-rule 1 or 2, as the case may be, and such delay is attributed to administrative lapses. Interest at the rate of 7% per annum for the period beyond 1 year shall be payable on the amount of gratuity. My submission before your lordship that the proviso says, provided that where a departmental or judicial proceeding as the case may be in respect of a pensioner is continued or initiated under Rule 7, the gratuity shall become payable on the date of finalization of that such proceeding, and the period of 1 year shall be reckoned from that date. Then, my lord, it is I am coming to the sub-rule E. No interest shall be payable under sub-rule E, my lord. E.
49(5)(e).
Yes, my lord. No interest shall be payable under this sub-rule where delay in sanction of gratuity due to the failure of the part of the pensioner to comply for sanction of gratuity with the requirement provided under the rules. And here, my lord, there is a dispute, family dispute. One Mita Varana claims that she is the adopted daughter, but the present respondent disputed. They file the miscase for legal error miscase. The Tahsildar allowed. Mita Varana challenged it in the appeal. The appellate court, the sub-collector says, I am not the competent authority. You go to the civil court and obtain the succession certificate, for which there is delay. And as per my lord's order, I have already, we have paid the amount, the principal amount on the next day, my lord. Order dated 7.
Please for the other side.
Well,
Yes, madam.
my lord, that was a 3,13,000, but they have paid 3,03,000.
You are entitled to 3,13,000.
My lord.
Let us put her grievance by calculation, how she is claiming.
That was their official calculation filed
before the single judge.
My lord, their official calculation.
Where is it?
In the my pension form. They have calculated in the office that their office calculation that it is 3,15,000. I have
So it is there in the form. How will we see it?
That is 3,13,496.
Right. This can be sought out.
My lord,
This can be sought out at their level. My lord, your lordship, my directive. This is their calculation.
See, if we deny her this 12%,
yes,
or him, whosoever, then we will be interfering with the order.
My lord,
that is not required.
My lord, because that is the rule. Because I am before your lordship, that rule requires.
Rule framed when?
may kindly be seen.
Rule framed when? When was that rule framed?
My lord, it is 92.
Okay.
She died. Her husband died in 2010.
All right.
Husband died in 2010.
10, madam.
She's getting in 2024.
24. Because of their lapses, madam.
Their lapses?
No, my lord.
How can you
They
say
are
that?
quarreling each other. At the time of payment of gratuity, they went to.
Who's they?
My lord, the daughter, mother, and son.
Who filed the case? Who challenged it in court? They did not go, the other side went.
Yes, my lord.
So how can you blame them?
Because they are party to it. They have.
They are party, they are the opposite parties.
My lord, in this case,
Yes,
they have filed the miscase before the Tahsildar.
first succession certificate.
why not
Without
I-
that, you will not grant.
Why not? It is not a very
Exactly.
short point. As your lordship pleases, the law says that if your
Unfortunately,
lordship
somebody
is
has
inclined to grant
disputed.
him, I have not the way. Lordship granting 7%. That is the statute. That is the rule.
Your lordship may kindly peruse their counter affidavit annexure.
No, we are not interfering with the present facts. The TP, what is that? So and so as this appeal has, intra-court appeal has been preferred by नाम लिख दो complaint का, putting to challenge an order dated 30/4/2024 passed by a learned single judge of this court in WPC number 3515 of 2023, whereby learned single judge has held the petitioners entitled to payment of amount of gratuity with gratuity. Who died? Their
Father. You are the wife or the daughter?
He's the
I am the wife.
Wife. Husband.
Wife and son before only.
Wife and son.
Okay. Respondent 1 and 2.
2.
Yes.
consequent upon death of an employee of the corporation. It's corporation or company?
Company.
The
Company. Tata Power Company.
Yes.
company.
At that time,
By that time, it was SSU. It was not a company.
Interest at the rate of 12% per annum from the date the same became due. Full stop. Petitioner number 1 is the widow of the deceased employee, whereas petitioner number respondent number 1 is the widow of the deceased employee, whereas respondent number 2 is the son. Full stop. Learned counsel appearing on behalf of the appellant has drawn our attention to Rule 49, bracketed 5 of Odisha Civil Service Pension Rules
1992.
1992 to contain that interest at the rate of 7% per annum is permissible if payment of gratuity is delayed by more than a year. So stop. He has further submitted that in the present case, payment of gratuity got delayed because the respondents, because of family dispute, because of family dispute as regards entitlement of death cum post retiral.
All benefits are taken, but no except gratuity.
no, but dispute was regarding.
Only gratuity.
Dispute was also regarding. No. Regarding that litigation.
Yes.
So all benefits she must have.
Yes.
Death cum retiral benefits of the deceased employee. So stop. He has further submitted that there is a direction by the learned single judge also to consider the case of one of the dependents of the deceased employee for appointment on compassionate ground. Stop. He has submitted that
there is no such
provision for appointment of compassionate appointment on compassionate ground. Rather, there is provision for payment of compensation in lieu of such appointment.
Has that been paid?
Pardon?
Has that been paid?
No, my lord. That
Okay.
No. She has not applied.
We have applied.
Stop.
So while deciding, you
See, they are waiting for a appointment,
Next.
therefore they have no
In
problem.
the present facts and circumstances of the case, comma, considering delay in payment of gratuity, we are not inclined to interfere with the order passed by the learned single judge requiring the company, of course, requiring the applicant to pay 12% interest on the amount of gratuity. Stop. Further, the other direction, that is to consider the case of the dependents for compassionate appointment on compassionate ground does not require interference, as there is no specific direction to appoint. Rather, the direction is to consider case for compassionate appointment. Stop. We accordingly decline to interfere with the impugned order passed by the learned single judge. The writ appeal is, however, disposed of with an observation that let a decision be taken on the taken as regards claim of the dependents for appointment on compassionate ground. Stop. If such claim is rejected based on policy of the
Once it is
applicant,
rejected,
comma, the amount of compensation must be paid within.
she is entitled for 1.5.
At the present rate, madam.
Within 1 month. Within 1 month from today. Stop. If the said amount is, it goes without saying that if the petitioner's case, if the case of the dependents for appointment on compassionate ground is rejected and the amount of compensation is not paid, comma, that shall earn, the amount shall earn, the amount of compensation shall earn interest at the rate of 12% per annum.
Later, make an application for that. That is the scheme.
so we are rejecting in that
Make an application.
about interest and the peculiar facts of the case. All right.
We
Let her apply within 7 days. Let her apply for that monetary benefit.
we make it clear.
At the present rate, let them pay the
He
amount.
can
in the present
apply
rate.
only after you reject the claim for appointment.
That is once rejected, my lords. This honorable court directed and it was rejected.
Oh.
That is my counter main. Earlier, it is hard rate applicable.
My lord,
But
they are
you should have paid
taking
the amount of compensation.
out of source, they are taking,
No, if it had
Out
been
of-
earlier rejected, you should
they are
have
taking
paid.
out
Yes,
of
sir.
source service.
All right, we'll consider.
Outsourcing, consider in my
That-
case.
That you can
Outsourcing.
file, that you can file separate for otherwise considering, not
For
under this.
outsourcing, you will have to approach someone else.
My lord, at present rate, money may be granted.
Present
Evaluation-
rate, it will be less than what we have ordered.
My-
Did you hear the rate of interest?
my-
Item 14, in the last order, your lordship directed the state to file a copy of the writ appeal because they have filed a counter cross appeal. They are not served. May direct that so that they can serve me a copy and the matter can be taken up next week. Item 14.
Yes, my lord.
You will come. Control over the office of the Advocate General.
My lord,
You don't have any control over your
I requested quite
colleagues,
my
your...
lords, my control has ceased in the meantime.
Why?
Change circumstances.
Oh, no.
So I have requested Mr. Pati now. He is to serve me a copy.
Your desire is enough. No.
And that he can come the next week.
Yes. Mister, please ensure.
Yes, full short.
Sir. Why?
Next
No
week,
order
my
is required.
13.
No order.
Item 13.
No order is needed, you will get. You direct them.
I'll see that I'll try to get a copy from him.
No. Yes. They'll give you. Yes, madam.
Item 63, Your Lordship, it's a tender matter. And I believe the board is very heavy today. Your Lordship may not reach. If I can get a date next week, Your Lordship. A little higher up in the list.
Please wait for some time.
Lordship.
Please wait for some time today.
Lordship.
We don't know. All right. Then 63. What is the matter about?
The tender matter.
Tender.
The affidavit not filed by the state.
Lordship. And Lordship are very particular that this counter should come early. The Lordship had appreciated the matter.
So this is the second date.
This will be the third day.
63.
You can find out what is the instructions.
63.
So let it know.
Alerted Mr. Devashish Tripathi, I will inform you.
You can be granted.
Item 63.
Item 63, when will you file the counter?
Item 63.
Please inform us.
Need 2 weeks time. 2 weeks. All right.
Check and receive paramedic comment.
Yes, ma'am. 1 week. 2.
Receive paramedic.
Yes. This matter and this matter on 1 week. 1 week. So as to enable and state council and AGA to file counter affidavit. Stop. Learned counsel for the petitioner shall be at liberty to make a mention for early hearing on the next date.
I'm sorry, man, 13 to come next week.
13th next.
That delay has not been condoned, nothing has been done in the state's appeal.
In that cases, my lord. But 13, that state case, there's a delay. I'm told that.
You are asking for the appeal memo in that case?
Yes, ma'am.
But so we can condone the delay today. Then they will serve the
That day, let him serve the copy, let me go.
What is the delay?
If it is in my.
What is the delay? How much?
What is the delay? Next item, item 13.
All right.
On that day, minors can.
I'm also.
On that day, minors can take it.
All right.
Mr. Das. The Lordship, stand permission. Lordship, on WPC 26430 of 2024. This matter was listed today before court number 6, Your Lordship. Since this matter is assigned to your Lordship, so therefore I pray this matter may kindly taken up today.
PG admission.
Yes, Your Lordship.
All right.
Before raising a few matters.
My lord, copies has not been given to me.
So before you made your mention, it will come tomorrow.
My lord,
The file was placed before me. I have already passed orders, so you are not required to make a mention.
Only difficulty is today is the last date for registration, Your Lordship.
Today it cannot be taken up. Today is last date for admission.
Registration, Your Lordship. Registering for the counseling and admission process.
We will take up that.
My lord,
Yes, you serve a copy of Mr. Manti.
today just now he has given me copy that the petition which was been filed, he has made a petition for amendment of the petition where made the PG council as a party that has not been accepted. So this is the status of the case.
Whatever.
And
I have,
and the last date today, but we can, as per if merit is there, we can extend
No,
for
which
registration.
course? Which course is this?
This is for PG course, Your Lordship. PG medical course.
PG
medical cannot be extended. The date cannot be extended.
Let us see what the matter is.
Yes,
Let
ma'am.
it-
No problem.
We will take up
Yes, ma'am.
at 3:30.
Yes. Give the memo a number, they
My
will
lord.
publish.
And another matter, Your Lordship, that is not on the board, that may also kindly be taken up.
How? And how and
2711 end of 24. It was filed. Your Lordship, the only difficulty is on 30th they issued the notice for registration.
So when did you file?
Yesterday itself I filed the petition, Your Lordship. On
Was the
30th on the
Other case you filed
Yes.
30th.
49. 49. Two matters are there.
You give two separate memos.
Mine.
Not connected. Are they connected?
No, Your Lordship.
So
Separate.
please give two separate memos on
Mine.
basis of that. Give him notice. Second case also,
Second case also, I'm giving the number.
you have to give us, no, you.
Copy, I'm serving a copy.
Copy, because he may not have brought his copy.
My Lord, I'll just sub.
Copy has been served on.
I'll just sub now.
Next time, please don't do that. Because it's a student's career, we are interfering. You please mention in the first hour or on the previous day, you could have mentioned yesterday.
I did not get the numbers for that.
No, that I understood for the single judge. That he is not that single judge, that's the other matter. Could have mentioned yesterday.
Matter fixed for 2 p.m. hearing, item 49.
Yes, Mr.
Yes. Lord, this is a repetition which has been filed by me, and my colleague will hand over a brief note for my Lord's kind consideration, which essentially in one line, my Lord, is for exclusion of a period of 5 years and 10 months, which were lost by virtue of a wrongful suspension of mining by the opposite parties. And while I'm
Mr. Jain, I'm sorry for interrupting, but were you before this court earlier? Were you before this court earlier? You're not aware? Mr. Nanda, you are not aware?
In a different form, my lords.
No, but
not on this. On this issue, we have
not on this issue.
This is the 2024 writ petition, Your Ladyship. On this issue, we are coming for the first time.
Earlier were 21 and something, I think.
No, Mr. Jain, the question is whether in relation
Yes,
the same
Lease.
lease or
no.
no.
Oh, I see. Yes, my lord, not in respect of the relief I've asked for in this writ petition. Obviously, there are many matters of the petitioner against the state, but on this
in connection
specific
with this
issue, my
lease.
lord, we are coming for the first.
Just a minute, Mr. Jain.
Yes, in connection with the
this lease, whether any applications, whether earlier applications were filed.
No.
What do you have your writ application? You mentioned somewhere that earlier applications were before.
3115. 3115.
Sorry?
3115, Your Lordship. Yes,
Earlier applications were before this court. That is where.
that is at page
Yes.
17. Page 17.
Lord, the issue of that earlier writ petition was that 20 years plus 10 years, which was a separate point by virtue of the fact there was an agreement with the government. This is for adding 5 years and 10 months by virtue
Mr.
of the
Jain,
fact that there was wrong suspension. And
The issue involved in that case, in those cases rather, may be different.
But maybe 10.
Can we know what were the cases about?
yes, my lord,
There is
I'll get a copy. Yes, we'll certainly place that for my lord's kind consideration. Let me place this in context, and we will get a copy of it, and I'll show you.
Your Lordship is asking for copy of.
No, we just, in fact, normally when you file a writ petition, you mention that whether you had earlier approached in connection with this or
In the declaration.
lease.
In the
So
declaration.
this is what. So whether there is such statement.
That is at page 3, my lord. Statement is the matter out of which this present writ petition arises was never before this honorable court as per instruction received from the petitioners.
In the present form.
They say like this.
The present form, the other writ petitions were there. In the present form is not there.
We should be clear. Our concern is that we should be clear about the past litigation.
May I? Yes. May I kindly have page 19.
Page 19.
Yes, ma'am.
Yes. Paragraph?
One second, just hold on. Not kindly have page 17 first, para BB.
17.
Yes, my lord.
Yes. We are there, Mr. Chan.
It is submitted that due to opposite parties' inaction in executing a mining lease for the remaining period of 10 years, the petitioners filed a writ petition 3115 of 21 on 25th January 2021. While the issue pertaining to execution of the balance period of 10 years is pending adjudication in the Honorable Supreme Court, the petitioner in writ petition 3115 of 21 had reserved its right to seek lost period of 5 years and 10 months. The relevant para of the writ petition is extracted, and that, my lord, is para 32 extracted at page 18, the highlighted part. The petitioner reserves its right to file an appropriate proceeding in respect of the illegal suspension of mining operation, pursuant to which the petitioner was unable to operate its mine in terms of the mining lease of 14th August 2001 for a period of 6 years. The petitioner craves leave to file documents relating to the above at the time of hearing. So I'm happy to submit all that in.
Do that.
Be some called in another court or something.
No. In fact, my colleague, I think
Apologies.
my
My lease was my hearing lease got terminated.
my colleague joins other. Now he has joined from his colleagues.
Am I audible now?
There is some problem with the connectivity here in Delhi, where we are sitting.
Because of the smog slightly building up.
Mirror, am I audible now?
Certificate. Any other case also?
No, I think everything is dropped. Mirror, am I audible?
Gopal, you are.
But not visible, Mr. Jain.
Audible, yes.
What is this? That possibly could not be his idea.
Mirror, I hope I satisfy the twin test of audibility and visibility now.
Yes.
Yes, I'm grateful. Not sorry for this interruption. That's the one of the perils of doing a VC hearing, that sometimes there could be a little lag. So, my lord, just as my lord had asked me, this is what we have mentioned, and I'm happy to, my lord, put all the documents and record if the court so desires for completeness.
Should be done, Mr. Jain.
I'll have it done, my lord. Now, my lord, I've prepared a brief note for my lord's kind consideration, which my colleague will just hand over, which has the sequence of events, my lord, leading up to filing of the present writ petition.
Yes. This is what you have. Yes.
My lord, it says brief note on behalf of the petitioners. My lord has the note.
Yes.
Yes. My lord, we'll start with page 2 for a minute because it has the sequence of dates, and then I will, my lord, come back to page 1 thereafter. My lord, I'm also, as officer of the court, I must point out, I'm cognizant of the fact that your lordship's court has passed an order in the case of G. I will be able to show, my lord, the situation is quite different. So I just wanted to point it out right up front that I've gone through the judgment, and we will be able to show that the situation is quite different. It's my duty to point it out right at the beginning. Now, my lord, kindly have page 2. My lord, this is an important date. 11th February 1999, the petitioner was issued a grant order for renewal of Block B for 30 years from the date of execution of the lease deed. Then, my lord, that date will come is serial number 3. I'm just jumping for a minute. 14th August 2001. In view of the grant order,
No, but
dated
Mr. Jain, before we take up this matter on merits, should
Please,
we
my lord.
not be clear about all the past litigations which you are referring to? We should be clear about everything. See, we understand the only point which the present writ application involves is, according to you, for a particular period, your license was illegally kept under suspension.
Yes,
And that
wrongfully.
period,
Yes,
wrongfully.
correct. Ma'am.
So that is and this is the only point which you are trying to make out.
Yes, that's right, ma'am. It's a short 1-point writ petition.
We do appreciate, but before we proceed on merits, we should be clear on that aspect. The honorable sister has rightly pointed out that those facts are missing, and in fact, that certificate about the that
issue
small
that-
thing, though technical, but we should adhere to.
Certainly.
That requirement.
I'll do that. Just to respond to what the court said in one line. My lord, if I may put it this way, there are two buckets, 20 plus 10. The other case is on the plus 10 bucket. This case is in the 20 bucket, where we are saying this period of wrongful suspension should be added. So in that sense, we are in the first bucket only. This goes into that. Of course, for completeness, what certainly, but only saying to that extent, but that is a separate issue. This is a separate issue, albeit arising from the lease arrangement, as my lord rightly said. That
And
is
there
the
is another
commonality.
reason. And there is another reason, Mr. Jain.
Please, ma'am.
Your connectivity is very poor.
All right. on that,
Possible.
You know, I would have
I'll come
continued,
in.
but Mr. Dan is already there. Otherwise, I would have continued.
No, my lord, Mr. Gupta can continue if his connectivity is better. We have to get my lord's ear. Whoever gets it is better off.
Absolutely, one way or the other.
My lord, we can do it physically. And if my lord so prefers, we are happy to do that. After filing it, we'll file it in 2 or 3 days' time. No difficulty at all.
If your lordship's of the view, we can file a short affidavit pointing out that this is it and this was
Please
the
do
prayer
that,
made.
Mr. Gupta. That will be better.
We'll do that.
Yes, my lords.
We'll do that. If the court has any apprehension, it's our duty to dispel any apprehension about anything
So
and
we
everything.
should be very clear about.
Absolutely. Absolutely.
Very well. We'll do that.
We'll do that.
All right. You also.
But as my lord rightly indicated, that at the end of the day, this is the short point that we will be.
This is the only
canvassing in
question. This is the only
petition.
question
Yes, ma'am.
involved.
This is the only question that we will be
You
canvassing.
can get the relief if you are in a position to establish that you were wrongfully your lease was wrongfully placed under suspension for particular period. You may
Yes,
get
and my lord, the answer to that also is a one-line answer that I had a valid EC of 2004 vintage. They wrongly treated me as if I was under the 2008 vintage, which documents will clarify it was 2004.
There is
Therefore, it was a case of wrong.
another question will arise, Mr. Jain. The consequence.
Please, my lord.
The consequence, even if we hold that it was wrongfully put under suspension.
Please, my lord.
What would be the consequence? What relief?
Yes, and my lord, fortunately, I'll show the language is added back. So the provision itself provides for adding back. So if we are right, as my lord rightly said, the consequence is stipulated, it is inbuilt. It says added, which I will show my lord. So that will be an inbuilt provision for the consequence, which is provided in the clause itself, my lord, will be my one-line answer as and when we address my lord on that issue. And it is a mirror image of the rules.
And there is yet another aspect, Mr. Jain, that we have a new team in the office of the Advocate General. New persons have joined. So
they may take some time.
AGA might not be well versed with the issues involved, and
My lord, if I may pun, this is a fresh lease. What my lord is saying, like a fresh lease, there is a fresh team. So obviously it requires a new look at it.
So, Lordship, may I ask them that how much time will they take? In the
Issues
meantime,
involved
file
are
My lord.
issues involved are these as
I'll go
have been
through it.
discussed, as
Because
indicated.
readings are perhaps
You-
complete because counter file, rejoinder file.
Readings, everything is
Yes.
everything is complete.
Please, ma'am.
Yeah, I've gone through, but I am in detail.
But you did not tell us anything that you're not prepared.
No, I am to seek adjournment
We
because
can-
Lord Senior is.
See, we wanted that once the hearing begins, it should conclude.
Lordships are generous to grant me that.
No, but
we do appreciate.
propriety demands you should ask at the first instance if you, in case you are not prepared.
My lord, just
Senior counsel have other work to do also.
your lordship needs a clarity with regard to previous litigation. What I can
Yes, you
That's
can
the-
file a short
Yes,
affidavit. File a short affidavit, just bring that on record. 2 weeks.
Your Lordship.
Mr. Jain.
I'll do it in a week's time because everything is ready. I'll do it in a week's time. Your lordship may have call it out next week. I'll be grateful.
All right.
Anytime.
Everything is ready. Just.
My lord, when we go for battle, we are fully armed and prepared. Whatever the court directs, we are ready to immediately provide it.
You're ready with the affidavit, why did you
No, not.
No, not affidavit. The document.
Information. With the information. All right.
Yes. Lord, one has to anticipate what may happen in the course of a hearing and be prepared when you are in the final lap, as they say, in a regular hearing.
List this matter on 1 week. Stop. In the meanwhile, let a short affidavit be filed on behalf of the petitioner, bringing on record the brief history of past litigations, previous litigations concerning the mining. What is that? What is the name of that?
Thakurani iron ore.
Thakurani iron ore.
B.
It's not Thakurani. It is Thakurani iron ore mines.
At petitioner's instance. There may be many litigations. You can know only such cases which were.
Try and put it in a tabular form.
Please do it.
We'll do that.
Lord AGA, you will address the.
My Lord and Advocate General will.
We
here to assist you, my Lord. Lord AG. That instruction.
All but no further observation.
Yes.
All right.
At Lordship, 1 week after means 19th at 2 p.m.
19th. Let it come on 19th. Make a mention in the morning.
My lords.
My lord, can it be just before 19th? I may have some. Can it be any day before 19th? I'll be very grateful.
Before 19th may be difficult, Mr. All right. 18?
18. Grateful.
Can I request your Lordship to have it on 21st?
Mr. Jan, just a minute.
I'm told they'll be prioritizing this one. I've overheard.
21st or 22nd, which is if convenient to this court.
21st, 22nd. The second half, this bench will not be there. 21st.
I'm grateful.
We are grateful.
Deeply obliged.
At 2 p.m. Lord.
We'll see.
Lord, if it's not at 2, can we make a mention in the?
Yes, you must make a mention in the morning. Make a mention.
We'll do that. We'll do that.
Grateful, man.
Item 14.
That is, my lord, petitioner is directed to supply the English translated copy with the Odia annexure.
You want the English translation?
You don't require it.
I have learned Odia.
So Mr. Kaur needs it.
Harrison replies by the collector, Sundargar, and Chief District Medical Officer, Sundargar not yet filed. Counter affidavit not yet filed. That got
AI.
down.
This is AI.
It is reading that causeless noting.
Previous order.
Narek Sundar B.T. Panda versus 60.
It can read your petition also.
Sound
Sound mute kar diyantu so that no such problem will arise.
Yes.
If your lordship would recall, when we should meet a free space, unless this again we hit it, and something new will come up. Your lordship, on the last occasion, my lord, I was arguing a case. That the respondent, the successful in the writ petition, my lord, she doesn't come within the service area. She comes from the another basti, another sai. We call it sai, basti, or pada, whatever it is, my lord. That document I have filed in Oriya, my lord, as per directions, your lordship. I have supplied the translated copies in English. Your lordship may start with look at page 16 first. That is the notice inviting application, your lordship. My lords have been looking at it for quite some time, but then I will take your lordship to the page 16.
When?
My lord?
No, you said we are looking at it since some time.
16. Your lordship must be dealing with these writ appeals and all that for regarding Anganwadi matters. Anganwadi. प्रार्थीनी जो अंगनवाड़ी केंद्र निमंते आवेदन करिवे से सही केंद्रर सेवा अंचल स्थायी बासिंदा होइथिबे समस्त सेवा पाउथिबे.
English translation ko page.
The applicant who applying for the post of Anganwadi worker must be a resident of Anganwadi service area of the AWC. Anganwadi center must be getting all facilities from the Anganwadi center area. This is number one, your lordship. My contention with your lordship was
page, just one moment, page 90. 90. You filed it along with an affidavit.
Yes, my lord. Page ku jai nahi.
I don't understand. You don't give the proper noting. Sorry.
First document of the affidavit. Serial 3.
Applicant should be belong to SC/ST women.
No, those are not the controversies.
3.
The applicant applying for the post of Anganwadi worker must be resident of the Anganwadi service area of the AWC and must be getting all facilities from the Anganwadi center. There are 2 Anganwadi centers in that village.
Why is that must be getting all facilities?
Your lordship?
That second thing must be getting all facilities from that AWC area. That also you have to prove.
I don't know that.
That is not in controversy.
That is not in controversy. Controversy is, my lord, she belongs to a service, she belongs to another
whatever, whoever.
Anganwadi worker, the respondent 5.
No, that must be just to establish that she's a resident of the area, so she's availing the services of that area.
Yeah, that is impliedly.
Yeah. Not implied, that is the specification.
No, area, we might be belonging to that area, we may not be availing, that is another matter, but that she is entitled to avail those. Now, your lordship.
The word is must.
The
word is must.
I don't know.
You have translated.
Which one?
English translation is must.
Must. Samasto seva pauthibe. Sabu samasto seva must be getting. Then your lordship that there are 2 words in that village. I had shown your lordship the page 54. Is 20 brother?
Yes.
Is 20.
Yes, that is the only dispute.
A dispute now that I belong to the right place for which advertisement was made, I will justify that by taking the lordship to page 48. 48 corresponds to my lord.
No, but the learned single judge has taken a view. Which view is which?
Yes.
Part of the view is incorrect.
Incorrect is this, your lordship.
Page 48.
Page
Again in ODI.
Page 48. No, 48 starts at 48.
48 is the voter list, man.
Page 48 starts at
What language?
54 is the relevant. Sorry, 51 is the relevant page.
In fact, Mr. Sarangi, what I propose to do is that I'll get the matter listed before appropriate bench. Otherwise, I find it very difficult to have Odia and then English every time. All right.
And these Anganwadi matters, mainly they have ORIA documents because it will be the advertisement will be in ORIA. The certificates also.
So many things, names.
May I pray it this week?
Huh?
This week?
Next week.
Stay tomorrow.
Next week.
Next week.
Some other games.
Monday or Tuesday. Monday.
Thank you, lordship.
Before.
15.
May I please your lordship? Lord, the petitioners are before your lordship seeking review of order dated 7/8/24 passed in writ appeal number 1981 of 24 by this honorable bench. Now the brief facts are like this, my lord. Yes. The opposite party, my lord, within.
Let us see the order.
Yes, my lord. It's at page number, my lord.
Annexure.
It's at annexure 5, my lord. It starts at page number 219.
Annexure.
Annexure 5, my lord. It starts at page number 219.
Oh, no, annexure 5 is this is a review petition. 224 of 2024.
Pardon, my lord?
Yes.
This is review, my lord. This is review before.
Copy, annexure R5 is copy of D4 or something.
No, it's at page 219, my lord. May kindly see. 219 it starts, my lord.
Just a minute.
I'm
215.
219, my lord.
Yes.
Yes. My lord, what had happened in this case was that the opposite party, my lord, within 4 years of his retirement was visited with a disciplinary proceeding and an punishment of reduction of pension of 1/3.
No, you are seeking review of the order on what ground?
Yes, my lord. The ground is, my lord, what had happened, this punishment was imposed under UCO Bank pension regulations. Pension regulations, my lord, that regulation 48(1) proviso states that before any punishment is imposed, the board of directors has to be consulted, my lord.
In this, we have given a direction that after consultation with the board.
What had happened, my lord, there was a miscommunication by the zonal manager who filed the counter affidavit. And that aspect he was silent because in the writ application, the petitioner, the opposite party here before your lordship, had taken the plea that he was not served with a copy of the consent of the prior approval of the board. To that, The reply was that that was not necessary. So before the single judge, my lord, while confirming the punishment on merits, he was silent on this aspect. So when your lordship queried from me, when the writ appeal was taken up on the bona fide belief that such an order had not been passed, I gave a statement that yes, that had not been done. So your lordship set aside the order of the punishment of the single judge solely on this ground while confirming it on merits, giving the competent authority 2 months' time to pass an order afresh. So when this order was communicated to them for compliance of your lordship's order, they sent the documents which I have annexed that they have in fact, prior to passing of the order, that the approval of the board had been taken. So that is the sole ground I am before your lordship. So that document also I have annexed. If your lordship will kindly see page 248, that is on the agenda, that is the item number 5, and there also that is prior to my lord passing of the order of punishment. It was on 29/1/18. The approval was on 22/6/2017. So that from paragraph 6 at page 224, your lordship, based on my submission.
It's very difficult then.
And
you have really embarrassed us.
My lord, I am extremely, my lord, sorry for this, that there was a bona fide mistake on the part of the competent authority and the zonal office, because of which this anomalous situation arose. And I
that was the only question on the basis of which the writ appeal was disposed of.
Yes, my lord.
The only issue.
Yes, no, my lord. There were 3 issues. He had challenged the.
Yes. Please come to paragraph 8.
Yes, my lord. Yes, that is why I was starting from paragraph 6, because it was on my submission, your lordship passed that order.
No, we will issue notice, but subject to you paying cost of 1 lakh. Not less than that. No less than 1 lakh. You are right.
My lord,
The order requires to be reviewed.
My lord,
But before
can I give a judgment of the apex court?
Who are you?
I am the competent authority, my lord, who are the writ appellate, my lord.
Competent authority means what?
The general manager.
General manager of what?
Of UCO Bank, my lord.
General manager of UCO Bank. So we may initiate contempt proceeding against him.
My lord, the fault, he did not file the counter affidavit. The counter affidavit was filed by the zonal manager, my lord.
Whosoever has filed, the bank has to pay. Pay 1 lakh, seek instructions.
My lord, if 1 lakh your lordship imposes, maybe some other law will be there before your lordship on the next day.
1 lakh is nothing. Yes, we will take up your case next day. You just seek instructions. If they want, we are prima facie satisfied that if that is the position, the order requires to be reviewed. But because it was because of your fault, you will have to.
My lord, may I show one thing? My lord, totally, I cannot say it is my. Sorry.
No less than 1 lakh.
My lord, may I just show one thing just to, I am on cost, I have bowed down, my lord, but on the quantum, I just want to satisfy your lordship that I am totally not at fault also, because if your lordship will see the writ petition, how he has varied on this point, I'll just show, my lord. At page 35, I'm reading out one paragraph, my lord, that the petitioner respectfully submits that according to first proviso of subclause 1 of regulation 48 of the pension regulation has not been followed, as no letter to that effect has been communicated by the petitioner. Now here he takes the plea that under the proviso, I should have been communicated that letter. But if your lordship will see the regulation, it only requires prior concurrence.
You may be right.
So there may be, my lord, some ambiguity and confusion arose.
Right, but see,
my lord, I am totally in agreement with the lordship cost. It is my fault totally, in the sense zonal manager, and as I was the lawyer there.
What you have pointed out, all the more reason you would have controverted that submission.
Yes.
Saying that since the decision
I have
has been taken.
it in saying, if your lordship will see, page 110, how I have contributed it. Why that ambiguity arose? Because he said that I have not been given a copy and that is the requirement of proviso.
Mr. Counsel, that might not have been a requirement, but the requirement of the board, what is that?
My lord, the board of directors of
The consideration by the board, that was statutory. That was not done.
My lord, what he was saying is, my lord, it is not that not done. He is saying it was not communicated to me. And my reply was, it does not require communication. There the confusion, my lord, arose. That is what I was pointing out in my what I filed before a single judge.
Did you take this stand in your counter affidavit that the matter was placed or there was approval or whatever, there was consultation with the board of directors?
Which was not, but it was not necessary to be communicated.
Yes,
that you had taken.
No, my lord. I had told that it is not required to be taken. That he has to be given a copy of
So
the communication.
where is the reply?
Page 110, your lordship may see. What is my reply to that paragraph? Para 13.
You produced decisions, I think, regarding consultation with the board and everything.
That is.
Presumption.
Yes. Because, my lord, I was under the impression, as given in the counter affidavit,
So who prepared the counter affidavit?
the zonal manager, the then zonal manager.
No. Who was the counsel who prepared the counter
I
affidavit?
had prepared it.
Paragraph 6 is very clear. Paragraph 6 of the order.
Of the order.
Paragraph 6, madam.
Yes.
Paragraph 6 onwards.
Has not disputed the factual position. Yeah, possession.
Possession, it has wrongly been written, madam.
Position should have been position.
Paragraph 6.
Yes, because when your lordship put the query to me, my lord, because what was there on record, I could not have told beyond the records, my lord, to your lordship at that point of time.
As you seek instructions, if you are ready to pay.
Lord, cost, naturally I have to pay. I have unnecessarily burdened your lordship with this case, but if it can be on the low
Not
side.
you, the bank. The bank will pay. The bank has a lot of money. The bank has no dearth of money.
May I pray if your lordship is so inclined that that such a huge amount of cost, if your lordship is going to impose, then I'll have to get a certified copy and send it to them, my lord. I think it can come after 10-15 days.
I mean, certified copy means asking whether they can pay.
Not whether pay,
Then
compliance of your lordship.
no, that once we pass the order, you'll get the copy.
Or even if it is uploaded, I can also.
No, this is our view. Either we may consider, we may not consider. So today you are not here to bargain.
No,
like
I'm not-
you want us to record that this amount shall be paid, it is required to be paid, and then you will seek instructions whether this is to be done or not. This is not a.
I'm not done, not my
No,
lord.
no. Once we pass the order, that you have to comply or you'll have to challenge. So your submission is
No, what I was.
called for.
Maybe I have.
The petitioner in the The
Not
petitioner
yet.
UCO Bank, in the present review application, has sought for a review of this court's order dated 7/8/2024 passed in WA number 1981 of 2024. Full stop. While hearing the review application, we have noticed a typographical error in the second line of paragraph 6, the said order, wherein possession has been typed quote unquote instead of position quote unquote. Full stop. The said order shall be read accordingly. Stop. Next. It is apparent from the order under review that this court interfered with the impugned judgment dated 25/6/2024 passed by the learned single judge in WPC number 15143 of 2019 on the sole premise that the board of directors, that the board of directors of the bank
UCO Bank.
was not consulted, comma, which was condition, which is a condition precedent for passing of an order of punishment under the proviso to regulation 48. Second proviso.
Second proviso, is that
First
correct or
proviso.
not?
First proviso.
First
Then
proviso.
there is a mistake.
First proviso.
Paragraph 5.
Paragraph 5 of the order, come to paragraph 5.
Pardon me.
Is it second or first? It's mentioned second or first? In paragraph 5,
Second proviso, madam.
under the
Actually,
proviso.
it should be the first proviso, my lord. It has
Proviso
been-
cover, under the proviso to regulation 48 bracketed 1 of the what is the name of the regulation?
My lord, UCO Bank Pension Regulations 1995.
UCO Bank bracketed employees
Pension Regulations.
pension regulation 1995. Stop. The said order was passed considering the stand taken on behalf of the writ petitioner as well as the bank. Stop. Next. Learned counsel appearing on behalf of the petitioner submits that out of inadvertence, it could not be brought to this court's notice that the board of directors was already consulted before imposition of punishment in accordance with the proviso to regulation 48 bracketed 1 of the regulations. So stop. Next. We find from the materials on record that no such plea was ever taken, that the board of directors was consulted. So stop. It appears from paragraph 6 of the order under review that learned counsel for the respondent, comma, learned counsel for the appellant, counsel for the bank, comma, based on the pleadings on record, comma, could not dispute the factual position that the board was not consulted before imposition of the punishment. Full stop. Next. In view of the statements which have been made in the review application, it appears that the bank adopted a casual and cavalier approach in conducting the cases before this court. So stop. In such view of the matter, we make it clear that we shall consider the issuance of notice to the respondent or opposite party. To opposite party, we shall entertain the review application on payment of cost of rupees 1 lakh to be deposited in the account of High Court account again.
High Court no legal aid account.
No. So that
High Court a separate account
in the account of Retiral within 15 days from today. This matter on 3 weeks.
Item number 16.
My limited and small prayer in this case involved is, my lord, there was an tender for a query, and I was also selected for plot number 78. That is the dispute here. I have deposited the fees as per their requirement. 21 lakhs somewhat I have deposited. But later on, when the clearance of this environment clearance was sought for, they found from their own, instead of 70, it should have been 61. The plot number was defective according to their own survey and one advertisement. Instead of correcting their record, what they have said, they cancelled that. The collector is directed to the Tahsildar to cancel the lease. So I am the sufferer. I can.
How can they correct the record? Because if you got
No, because it's their fault, my lord. What mistake I have committed? I have applied for.
They have cancelled what?
The total tender. Then, my lord,
cancellation.
No, my lord, I approached the collector. Collector, what is directed? He directed actually who is the person involved in this case, why this defect has been. They found that is at Annexure 11. My lord will see. This is the same mistake for last 5 years. Prior to this tender, it was a 5-year lease. The same advertisement was, same tender was floated about plot number 78, and it was given, but the actual demarcation was given to plot number 61, and query was carried out for 5 years. The same mistake covered, but when I applied, they found the mistake, and that is why I came before this honorable court for, because of that report was called for, and report was in against those officers, not against the person, because I have deposited money, I am bona fide lessee. No. Now, this honorable court, I come before this honorable court on the earlier occasion because the report was in favor of mine.
just
Mine.
that letter you are referring to, page 36. What is written in the last paragraph?
Last paragraph he has stated, basing on the previous record, that's 37 minutes.
36.
37 last
36 last paragraph.
Oh, 36 last. Yes.
Accordingly, after following due procedure.
About 2 stone queries, Tadabala 1 and Tadabala 2, over plot number 78, Mouza Tadabala, were identified by the then Tahsildar during the year 2015, and proposal were sent to district office for declaration as a Sairat source. Accordingly, after following due procedure and above queries were put to auction during 2016 and being operated over plot number 61 and 32 instead of plot number 78 since January 18 on 5 years lease basis on execution of lease agreement by the then successful bidder and work order issued by the then Tahsildar after obtaining environmental clearance from the DEIAA. The facts regarding identification of the quarries over the wrong plot number had not been detected by anybody since then, and quarries were being operated over plot number 6132 instead of plot number 70. This is previous part. I am the current, I was not the person there.
No, no, that means
The mistake
actual plot is 78.
Nah, actual plot is 61 and 32. 78 they have advertised. Sorry, that they have
Read the last line.
Yes, my lord. Being operated, then the quarries were being operated over plot number 6132 instead of 78.
What does that mean?
Like 78 auction was made. But on
Previously,
yes, the same thing occurred.
Previously also, instead of 78, it was being operated on those
61 and
plots.
32 because the identification was made by the Tahsil office. So he is the person who was there previous to me. He has operated the quarry and over plot number 6132, 5 years, 2016 to 21. Again, the same mistake that issued 78. Only in this, now let's parameter, can you see? Basing on previous record and after completion of the old lease period, fresh auction has been conducted for the above said queries and auction sale process has been completed.
No, what you had earlier come?
No, earlier come for this mistake, this report.
What was the order in the earlier?
Order only this annexure 11, what I have read out, that was directed to be considered by the collector.
Representation.
Yes.
Okay.
This annexure 11 was directed to be considered. Because this report, I am not at fault. This court has directed that yes, you consider the collector. Now the collector has rejected it. On this in order, my lord, kindly see page 12. No, sorry, page 39, annexure 12.
Yes, we are there.
My lord.
Annexure 12, page 39.
Yes. After my lord's order, in the previous writ petition, he has said, in connection with subject matters of, I am directed to intimate you the decision taken by the collector on annexure 11, pursuant to the order dated so and so, so and so. There is discrepancy in land schedule in respect of Tadabala 1 and 2 stone quarry in view of the above consideration of annexure 11 doesn't arise. But annexure 11 there is not. And I am nowhere at fault.
No, you may not be at fault.
Yes,
but unless the plot is properly identified, maybe it cannot put to auction also.
Correct, my lord. Now, what I beg to sub, because kindly see, my lord, they have collected money from me. I have deposited page 22.
That they will return that.
That not. That is the difficulty, my lord. If at all they will return the money, they should give me with interest.
What is the amount?
21,48,090 rupees. Page 22, my lord. That receipt is there. And further, I have to deposit 40,000 for other cost, material cost and all these things. I have to deposit. And in the meantime, because they have settled the tender in my favor, I have procured the machine, other things for the purpose at this site. And when this clearance for this environment clearance was sought for,
For that you will have to file a suit. If you want compensation and everything.
No, not compensation. That
amount you will
I'm not playing here also.
No, the amount which you
I'm
have.
not praying for that.
The amount which you have deposited, you will get.
With it, at least.
When had you deposited?
That was deposited in 4/2/23.
4/2/2023.
Yes.
Yes, file your affidavit.
Madam.
Let a counter affidavit be filed on behalf of the state. In the counter affidavit, it must be specifically mentioned as to whether the opposite parties are inclined to refund the amount of rupees 21,48,090
and another 40,000 for other purpose.
40,000 or No, you tell us what amount you have deposited.
For preparation of mining plan. Para 4 I
refund the amount deposited
preparation mining
petitioner for grant of lease pursuant to the which notice?
Annexure 1.
Pursuant to Annexure 1 I cannot read. Pursuant to the notice dated 2/1/2023 issued by
Tahsildar
Tahsildar
Lanjigarh.
Lanjigarh.
bracketed annexure 1. Full stop. The court may consider issuing direction for a refund of the said amount with interest. And if you pay that with reasonable interest, just you can suggest how much interest.
I will take it.
In fact, by this time you should have returned.
I will take it. Whether it is done. But so far the case is concerned, my lord, they have not challenged the cancellation. And
Cancellations, you have done that. They
have
want
not-
their money back.
yes, madam. Only money is.
On what ground will they cancel? Challenge the
And if
cancellation.
it is a case of cancellation, they have to go and appeal. I will
Appeal.
take it.
Cancellation, they cannot challenge.
What is the use of challenging because it is not that plot?
For no, for the person has been harassed.
2 weeks. 2 weeks within first 5 cases. They expedite it.
Madam,
Pay the amounts, not a list at all. Yes.
Item 17.
May I please, Your Lordship. On the last occasion, my lord, an instructor stayed to file an affidavit, my lord.
Filing the affidavit, but the matter has become such a lordship. They had investigated, made an inquiry, and they found that one Renuka Parida, her age was less than 60 years. But they again inquired to her background, Your Lordship, checked her high school leaving certificate, checked it with the authorities also. They found that her age was wrongly quoted in the voter ID, Your Lordship. She's actually above 60 years of age. So now they have released her pension also, Your Lordship.
No, my
So
lord. In this case, my lord, total 19 numbers of beneficiary get the who are less than 60 years, my lord. I have already
23. They
received
had
that
reported
report.
23 and they have been
They'll
inquired
file
into,
the,
Your
the
Lordship.
affidavit, I'll file the rejoinder, my lord.
We are filing
In
the
ROF,
affidavit.
I have made, so that's why I'm not filing that. They'll file the affidavit, I'll file, my lord.
Today itself will file the affidavit, Your Lordship.
And it will probably not be infructuous. Look at the second prayer.
Council age mentioned in the voter ID is not the final entry for the purpose of determination of age. Can be other.
Out of here, it gets a list.
Yes. We'll file the affidavit today, Your Lordship. It's been drafted, so I'll file it.
Lord AG states that counter affidavit shall be filed by tomorrow. Stop. Copy or survey
Besides, sir.
unless this matter on 1 week, 2 weeks.
1 week.
2 weeks. 2 weeks.
Your-
For him to consider.
Your challenge is less than 60 years, they have been granted.
My lord.
You've done a good service to them. Do you know why? They will get from Subhadra Yojana, they will get now.
My lord, today in ROF, I have written.
No, no,
19
you have it.
there, my
For
lord.
them, it is a
Who have
blessing in
get that
disguise.
beneficiary, my lord. That's all. Any
Those
taken of
Those above 60 have been deprived. Now they will get.
What is that?
No, affidavit. Granted number official and-
Item number 18.
Obliged.
Matter was there before yesterday, I served copy.
Yesterday, I think the matter was there. From your lordship's direction.
You think the matter was there?
I'm sorry, my lord, I should have read. I was given a copy and I was informed by the senior counsel appearing that matter will be listed today. I took instruction in the matter to the engaging counsel has not got Bhaklatnama, and in turn he has not been given me the appearance memo.
Engaging counsel.
Engaging.
My lord,
Engaging counsel means the
panel lawyer.
panel lawyer. Okay. all right.
Panel lawyer. My lord, here what has happened, he is basically raising a grievance with regard to the introduction of the GPS system, tracking system in the vehicle which will take the paddies. My lord, this is a central government scheme which is being implemented by the corporation, and corporation is having no profit, no loss, only they get subsidy from the central government on the basis of the implementation of the scheme. And this guideline with regard to imposition of a tracking system is to ensure fairness in transportation, and in fact in the tender document itself, which has been annexed to the writ petition, there was a clause that there should be a tracking system, and the quotation he makes for the transportation should include also the tracking device expenses. That is there in the clause. Okay. In the agreement he has signed also, he has signed the agreement saying that he adheres to the tender conditions, and also there is a condition that he should also be subject to tracking system. Now, it was not implemented when the agreement was executed. Post facto that it is being implemented. But fact remains, it is there in the tender document, it is there in the agreement. So, my lord, I need also further instruction, whatever I could, because after getting this brief in the evening, I could take instruction. May I just point out, my lord, your lordship, the very tender document which has been annexed, your lordship will kindly
His
see.
term is going to expire in 2025.
Yes,
Yes,
31st March.
All right, so will you file affidavit?
I'll file an affidavit.
File.
Madam. Because page 56, the tender document itself, clause WY indicates that there should be a GPS tracking system.
Page 56.
Madam. The transport contractors shall install GPS tracking system. Now, instead of installation of this tracking system, we have made it more simpler by saying that you should have a mobile phone where there will be app. So that app will do the tracking. Even no requirement of installing a GPS tracking system, which may also incur some more expenses.
That is beyond the tender notice.
We can implement this one because they had a grievance with regard to the expenses, which includes, their quotation should include the tracking system expenses. That is what is mentioned in the tender document, my lord. That your lordship will kindly find from why.
What is your problem?
The present Annexure 5, your lordship kindness.
No.
The Annexure 5, what they have said is, now the vehicle tracking system should be there. Based on mobile application,
Yes.
for which they said that there will be training and all these things. These were not the terms of the contract. But as your lordships have rightly observed and felt from your lordships, the 31st March is the tender closing.
No, but which driver of your does not have a mobile phone?
Well, every day drivers change, my lord. The vehicles, every day I don't engage a single vehicle.
Then it is difficult.
That is right, my lord. That's why.
Then it is difficult for you to
Operate.
this. If you can't have
Regular
even a regular driver and mobile phone, then it is very risky for the
No, their
opposite
Aadhaar
party
card
to
and other things are kept.
do business.
Their
Because
identity
you
is
also
secure.
have to track your own driver.
That is correct, my lord. But
Unless he goes out of the route on your instructions.
he should not also. That's why I don't dispute the scheme. What I say is, I have almost completed the entire contract period, and now at the fag end they want me to.
There is also
invest.
another problem. Most of the time these things
Let
get
us keep the matter
reviewed.
pending for some time without any interim. File your affidavit. 4 weeks time is allowed. 4 weeks time is allowed for the estate to file counter affidavit. This matter, 4 weeks.
But in the meanwhile, you take instructions because as far as experience shows, these contracts are renewed. So
No,
there,
that was extended only up to 1st of.
no, This happens until fresh tenders. Mr. Mishra will also tell you.
In fact,
So that you will be deprived.
Unless they encourage disqualification by some kind of act which disqualifies them, usually they are repeated, my lord. As your lordship was pleased to observe, my lord.
Just bringing
Because
that.
the corporation has no prejudice that way.
This annexure 5 may not be insisted till then.
No, but are they insisting that letter is there?
That
are
they have given
threatening
the
any
date up to
jurisdiction?
1st of November. Also.
What is that letter?
Oh, they
But that 31st deadline is gone. Today we are on 5th.
Yes,
Till that no action has been taken.
no action,
And,
but I was
my
told
lord,
that they have extended it up to 1st of.
So that is.
Item 19.
What I say is they let them not insist for this.
Because of the stand which you have taken, we are not inclined. That your drivers, you are not sure which driver will be there.
No, every
When-
day there is a change of driver. They have an identity.
Driver.
Aadhaar card and
Maybe
other
having
things.
identity, they must be having, as of in 2024, in November, you cannot say, even the vegetable vendors, they are having.
Everybody will have the
The
mobile
rickshawalas, they are having mobile phone.
Why the driver? Whoever operates
That's correct,
that,
madam. I don't
No, what he is
stand.
saying that it is difficult for him to spend so much.
No, now what they say is mobile-based tracking system. Just mobile is all right.
Yes.
Tracking is nothing. Tracking will not cost you anything, not even a pie.
So meanwhile, you find out it actually is not difficult. Your drivers will become smart after attending all this training.
No, the drivers are smarter.
How to get
In fact, there has been instances of diversion. That is why this is being implemented.
No,
There are
scheme I don't
instances of
dispute.
diversion, my lord.
This is definitely in the interest of
Instances
everyone.
of diversion. So what they do, they change the food grade and bring something of lesser quality. And it is to, and we are also
No, no,
implementing a
these-
route system which will make it the minimum route required.
These
All
food
the-
grains they dispose of elsewhere and then substitute.
Exactly, that has happened. There are cases.
That is why you have the safeguard of these, what do you call these, godowns also. That must not be with your
Your
family
food
member.
corporation.
And for the civil supply corporation,
Food corporation.
in fact, they should make FCI and the government of India a party. They are not here. Because this is a scheme of government of India.
All
and
right,
it-
let us, you can take this plea.
My,
Non-joiner of necessary parties, whatever.
I'll definitely do that.
Item 19.
My please, my lords. Opposite party, my lords, one lord. Odisha State Road Transport Corporation issued my lord annexure 1 tender notice, my lord. That is page 9, my lord. Annexure 1, my lord. The tender, my lord, says, my lord. The sealed tender are invited and permitted to read, my lord. The sealed tenders are invited from intending person, firms, and institutions for license on rent basis of the OSRTC land and the building at Balarampur Pokhari, Charampa, Bhadrak. For details, please visit the website. Download such and the tender open last para, my lord, as stated will open on 26/7/2024, my lord. That my lord, short tender petitioner will participate along with others, my lord. The tender only box has opened. Nothing has been given to nobody has been successful. Nothing has given to somebody else. During my lord, the substance of this tender, my lord, annexure 1, annexure my lord 3, my lord, the impugned order before lordship, my lord. That is the order issued by the OSRTC, my lord, opposite party, to give my lord, use the land. To use, my lord, given opposite party number 6, my lord, to use the land for famous Kali Puja at Bhadrak, my lord. The land, my lord, the tender for purpose of the tender is to use the land for famous Kali Puja, which is already started, my lord, from 8 to, that is, my lord, next to, my lord. And, my lord, how the, during my argument, my lords, would my point, my lord, if, my lord, during annexure 1 is pending, the tender has opened, but nobody has successful in the tender, my lords. How, my lord, the opposite, putting the question myself, not the court, my lords, that how they have given the same land for the same purpose without issuing the notice to the opposite party number 6, my lord. That is an improved before lords annexure 3, my lord, not 2, my lords. Lordship kind have a glance.
Who is opposite party number 6?
Opposite party number 6 is private person to whom, my lord, of OSRTC, who is the owner of the land and the government, my lord, given the land to use the land for entire Kali Puja, my lord.
And who are you?
Kali Puja is how many days?
My lord, that 22 days, my lord. The land, my tender, usual my tender issued, my lord, and for Kali Puja use.
The tender was for what period?
Tender, my lord, they have not written the how many days tender will be given, my lord.
Not for 22 days. This is only for temporary period
Nah,
to earn some money
my question, my lord, lots of valid questions, my lord.
to yourself.
My lord, that my lords, that tender, my lord, issued each and every my lord, tender for use of the government land for Kali Puja, not other, the land never used for any other purpose, only for Kali Puja. No use for land for the land for other purposes, my lord. Only Kali Puja purpose the tender issued.
What is your problem? You're not able to understand.
My
You
lord,
are saying that they should not have given it to him. You should have opened the tender and given it to
my
you.
lord, usually that is your because earlier, my lord,
Their land, their wish. What is your problem?
no, their land they have used, but they have issued tender.
Yes.
Tender has
Tender basis of tender, they have not passed any order. So what is why are you aggrieved?
tender is my lord. Tender has not given to somebody else.
Then who are you? What right do you have?
My
What
lord,
right do you have?
I have participated in the said tender, my lord.
All right.
Tender has not given to somebody else, my lord.
Yes.
My lord, and view of my lord, with your permission, my lord, I was also performing the puja with her some permission of Honorable High Court in many occasions, and some occasions, my lord, every year I petition perform the Kali Puja using that land, my lord.
Say that. Say that.
And now, my lord, they have for that purpose they have issued tender notice. Somebody participated, including the petitioner participated in the tender process. That has not given to somebody else. How they have given, my lord, that land to use for Kali Puja, my lord.
How
That is
is
my
the like the that way? That is the impugn order.
All
That
right.
is how
The
Annexure 2, my lord. Annexure 3.
Mr. Counsel, is a frivolous writ application. It's totally frivolous writ application. So what do you want? And do you understand? Do you appreciate this? That this application is frivolous? Whether you appreciate this or not?
My lord, with your permission, my lord. My lord, सबसे पहले I will withdraw my lord merit application for lordship मला say so. I will withdraw my lord. I will bind down to my lord. But there is pendency of this my lord with your permission. I saying this tender process is not open, my lord. Given the same land for the opposite party was section.
their land.
I will withdraw my lord that time.
Withdraw your approach. You make that submission.
Lordship liberty.
Seeks permission to withdraw this writ application with the liberty to participate. You have already participated.
My lords.
With
Annexure 2 is my lord.
with the liberty to pursue his case before appropriate authority for expediting the tender process issued by tender notice dated 19/7/2024, bracketed in Annexure 1. Application stands disposed of as withdrawn with the liberty as sought. Yes.
Grateful, my lords.
Item 20.
Odisha Mineral Development Company. It's a Government of India organization. It issued an auction notice at page 56 of my writ petition for auction of its iron ore stack, mined iron ore stack. Now the petitioner is a trader. It participated in the auction, became the highest bidder. The sale order was issued. Delivery order was issued. After the delivery order, if your lordship will see the delivery order only at page 68.
Page?
Page 68. I'm so sorry, ma'am. Page 98.
98.
98.
Yes.
Annexure 4. Lordship may kindly see the delivery order date 1/7/2024. Lordship gets it from that column, serial number 1.
Yes, 1/7/2024.
24. The next just similar, valid up to who terminus with form L.
Where is that valid up to?
Form L. Form L is a permit under that.
Valid up to, where is that?
Valid, the second serial number 2. Delivery order
Yes.
date, your lordship gets it
Yes.
1724.
Yes.
The next is valid up to co-terminus with Form L.
Form L.
Yes. But Form L is an ambiguous because the Form L is applicable for a lessee. For a trader, Form I is applicable. So in my humble opinion is the providing this validity up to Form L is an ambiguous term, and under the principle of contra preferentem, it has to be read against the author who has written it. Not be that as it may. But pursuant to this order, Form I, which is applicable for the trader, was issued. That is at page 101. This is it is issued by the Deputy Director of Mines, not two authorities. But delivery order is by the company. Thereafter, since it's a protected material, the Deputy Director of Mines issues me the transit permit. And transit permit has been issued by the Deputy Director of Mines. Here they provided the validity period for which the permit is 18 July 24 to 16th August 2020.
18 July 24 to
16th August 2020.
this August 24.
Right. Now, using this permit, more than 50%, 4,000 some odd metric ton of iron ore was auctioned. Using this permit, I have lifted already more than 50% of the iron ore. Now, balance iron ore, I went on writing them. So please consider, Lordship, see my lifting data is at page 103 up to 105. 2041.040 metric ton I have already lifted. But page 106, I requested them kindly extend the date because there was heavy rainfall. The local villagers created some problem which is unforeseen, and on my part it is beyond my control. Kindly consider and extend the date. I lift the entire matter. But at this juncture, without considering this, without giving me a notice, without rejecting my request, they have placed the whole stock for the fresh auction. But the residual stock, 1,900 some odd, the residual stock, whatever is there, and I have paid for the entire amount, they are putting into the fresh auction.
Putting into?
Fresh auction. They have issued an auction notice that I am challenging here.
That auction notice, annexure 1.
That is the auction notice.
What was the clause relating to lifting of material?
That your lordship will again, it is annexure 1 is the notice which I am challenging.
Okay, your
Mine is at page 68. The same formal.
68?
Yes, my lord, 58.
58, sorry. 58.
I am so sorry. It is page 63. I am so sorry, my lord. I am so sorry. Contract period. Again, it is up to formal. Formal is not applicable for the trader. Formal is for the lessee. Lordship, see the form it has provided in the book rules itself.
No, contract is for it.
I think.
No, where is your permit issued by the Deputy Director of Mines?
No, that is at page 101. 101.
So A and D are relevant. D is in the event of non-lifting of material.
Right.
May at its own discretion either extend the delivery period or refund EMD.
Absolutely correct. Absolutely. But I only request the kindly consider it. But I have lifted more than 50%. I have paid for the entire amount. I am ready and willing to pay it if you give me 7 days time.
Yes.
Company, Government of India company.
Government of India.
Oh, who is a
But, in fact, I'll have to take out notice.
notice?
But I have an interim. Let it not be lifted, man. I'll kindly consider it.
That is in public interest. That if in the meanwhile they lift, you are entitled for the amount.
But I'm interested to
See, finally, if the case is decided in your favor, you will be getting the.
By that date, will not the whoever comes forward as the highest auction purchaser, he may lift it.
Any action based
Can
on.
I request, my lord, status quo as on today be maintained. Lord, I'll lift it. Your Lordship, just little indulgence of my lords, I'll lift it, man.
No, we cannot allow natural resources to remain like that.
But it is already mine.
Yes.
It is mine.
The mine, and thereafter they have to be used.
Lord, I
They have
can.
to be-
Lord, kindly
How
consider.
can you, without hearing them, how can we?
I am on what I'm trying, requesting my lord, kindly consider it, my lord. My material is left over, it is lying, my lord. I have lifted 50% of it, more than 50%.
Mr. Counsel,
Balance is only I am to lift it.
balance of see, without hearing the other side, we are not inclined.
My lords, if your lordship will kindly observe, fixing and short date, my interim prayer will be considered after they appear, my lord.
Yes. You make a mention. We will sure make any action taken
Lord, that
based on the online forward auction. Sure. That isn't what.
that they will go ahead. If your lordship observe that, that they will immediately go ahead and try to lift it, my lord. Lordship may keep it open. Lord, while issuing notice on the date of their appearance,
Issuing notice then.
my interim prayer will be considered, my lord, after.
Upon service of notice, it shall be open for the petitioner to make a mention for
Consideration of my interim prayer.
make a mention for early hearing on the point of grant of interim model.
Which mode do you want to take notice?
Lord, I'll be happy if it is by special messenger, my lord.
Because it is Bhubaneswar.
I can take it, my lord. Lord, if I can, if I can take it, little more indulgence of my lord's will. Subject to your permits me. Lord, if I'll apply them on my interim prayer, if lordship will give me an observation, that I'll request them. I'll at my cost, at my.
Where did it come? Sir, see, whatever you have stated in your writ petition,
Right.
that may be 100% correct. That, but
I would not have insisted so much.
correct also. You don't know. You are arguing a case of a client.
That's right, Lord.
Your client has filed the affidavit.
Lord,
Your
my
client has stated.
paid material, Lord. I have paid for it.
You have.
The whole material I have paid.
Let us
Once
see.
this third
Let
party
us-
lifts it
let
away,
us- let
that
us-
nothing will survive then for me,
Let us-
except getting back the money.
let
And
us-
money,
Let us see. Natural resources are very valuable. We can understand they are lying. If finally you succeed, you will get everything. Finally, you get what?
if they are
Finally, what do you get?
if they are lifted out,
Finally, what do you get? If they lift out, if they lift everything,
I'll get back my money only. And
money, what is the difference between money and
yes, there is a difference, my lord. I'll tell your lordship. Today, the cost of the material will be definitely more than the money which I'll get back.
Huh?
Today's cost of the material will be definitely more than the money which I'll get back.
It's good.
That
then.
is the issue, my lord. That is the problem for me.
Oh.
That is why I'm insisting so much. Kindly protect the material.
Yes. One? No. So you can make a mention after the note.
Today is 5th, my lord.
Last deposit by day after tomorrow.
Yes, my lord. I'll deposit by tomorrow evening.
You can make a mention once the.
Lord, once your lordship is fixing a special messenger notice, a date is fixed. Normally, a date is fixed.
Yes, we are fixing a date.
Fixed it, my lord, 11, 12, any date.
All right, 11th.
11.
You make a mention.
I'll make a mention.
See, we can pass interim order, but we want to hear the other
Absolutely
side
correct.
person also.
Absolutely correct. So grateful. 12. 12, my lord.
12.
12.
Lords, 21, I am on the virtual mode, Lords.
Yes.
Lords, Lordship, may kindly come to your Lordship's order dated 10/9/2024, para 6, Lords. Lordship's got it, Lords, para 6 of
Mr.
your
Rautre,
Lordship.
if I am not mistaken, you were arguing a matter for those in-charge headmasters.
Yes, yes.
Could you please give that case number? Because a similar matter was here. I couldn't remember the case. I only remembered you were arguing a writ appeal. Not today. You can ask Mr. Shekhar to give me the number.
Can I continue, Milords? Para 6 of your Lordship's order, Milords.
That mention matter.
Yes.
Mention matter.
Why on the special mention item?
That's what taken on board. WPC number 26430 of 2024 and 27118 of 2023.
271. Trust me. It is 271.
It is.
27 is. 118. Your husband try to hold.
On the laptop. More about 8 and 8. All right. Oh, chhad.
Yes, what is
Yes, ma'am. But I am with the petitioner, we are the in-service candidates. And we are appointed as doctors being recommended by the OPSC. And now we also look to page annexure 2 at page 21. The postgraduate medical selection issued this guideline for counseling and admission of candidate for the postgraduate medical and post MBBS course in 2024-25. And if you also will see that guideline, so far in-service candidates are concerned at page 26, serial number 2. Categories in-service candidate is one. You also kindly look to page 26, eligibility criteria. Serial number 2 must have qualified in NEET PG of
page number 26.
Yes. You also is holding 27118.
Matter mention is
27118 because the other one I
There's some amendment. So
amendment because
okay,
that was filed earlier. They issued the order recently, so they put it. You also look to 27118.
Oh, yeah. It is there in the
No, इसको बंद
pen drive.
करके हाँ उधर है नीचे वाला है.
All right.
Oh, scanning is doing.
Ah.
You also get it?
Page
Page 20. The guidelines start from page.
Annexure 1.
No, annexure 2 at page 21. This is the guideline.
Yes.
Postgraduate medical selection Odisha guideline for counseling so also 2024-25. You also turn to page 26.
Yes.
Eligibility.
Yeah.
2 must have qualified, serial number 2, must have qualified in NEET PG of current year, securing the qualifying mark as prescribed by MCI and NFC. Then also kindly come to the bottom 2, an in-service candidate. I am an in-service candidate because admittedly I was appointed as a medical officer. In-service candidate is one who at the time of application is under employment in Government of Orissa Public Sector Undertaking, Government of India Public Sector Undertaking located in Odisha, Public Defence Service in Odisha, and has completed a length of 3 years of service, including all categories of employment like contractual, temporary, ad hoc, regular by 31st March of the current year of admission, excluding at a stress level of any kind of 30 days or more. Then let's come to next page. NB. Next page, page 27. The cut-off date, let's get it at page 27.
Page 27.
Yes.
Next page.
This under the same category of in-service candidate, that is a NB. The cut-off date of 31st March.
NB.
NB. Yes.
I got.
Yes.
Got it.
NB. The cut-off date of 31st March mentioned above is subject to change as per any change in the schedule of NEET PG and All India Counseling, which will be notified. So far the NEET PG is concerned, let's turn to page 31. Because initially the NEET PG was notified on 9th January 2024. You'll also look to that. Yes, you'll also look to that. Initially, though it was notified on 9/11/2023, they have fixed it to 31st March. But it was changed subsequently.
in supersession of NBEMS notice dated 9/11/2023 and pursuant to the receipt of the NFC letter dated 3/1/2024, the conduct of NEET PG 24 examination, which was earlier notified to be tentatively held on 3rd March 2024, stand rescheduled. The NEET PG 24 shall now be conducted on 7th July 2024. That means after 31st March. This has been again changed. If your lordship will come to page 32, page 32, they again posted it. You also look to prepone, they prepone at paragraph 2. National Board Examination in Medical Science shall conduct the NEET PG 2024 on 23rd June 2024 on computer-based platform at various test centers across the country. But again, this has been changed. If you also will come to page 34, this was again conducted on 11th August 2024. Ultimately, it was conducted, NEET PG 24, now be conducted on 11th August 2024. We have appeared and we have also cleared. Now, in view of that NB, that has to be rescheduled. The last, the cutoff date, 31st March, is required to be rescheduled in terms of the schedule fixed by the NEET. Now, though they have issued this notification yesterday, just 3 days before, you also turn to page 35, annexure 4. The PG Medical Counseling Committee, they have fixed the date for registration from 1/11/2024 to 5/11/2024. That means today, 5 days. But they have not revised the date. So for cut-off date, 31st March, that still remain as it is.
But Mr. Rautra, these are the matters where we find very difficult to interfere. Because today is the last day.
No, it is registration, for the purpose of registration.
Date, not only any date cannot be altered.
No, that
is what the Supreme Court says.
My respectful submission only, because they themselves in the guidelines said
You
that
are
will be in
right.
accordance with the reschedule.
You are right. You are right.
Otherwise, I'll lose with the petition.
This has been done so many times. Don't you think they will do it themselves?
But they have not done it. In fact, the first writ application was filed before issuing this letter. We are under the impression that they will issue, but they have not issued. If they can take that responsibility, sir, I have nothing to say.
That they will take of the last NET they will take.
But now it has been fixed to August. So at least cut-off date should be at least till the end of August, 31st August.
Yes, in current year, that means they will take up of the last NET.
My lord, may I submit, my lord? These type of matters were before the Honorable Court in 2022. The NEET, just a minute, let me please. The NEET has enhanced the cut-off date. Accordingly, we have issued an corrigendum for extension of the date, 31st March to 31st of May. That was challenged in this court, and the court held that you cannot issue the corrigendum, and 31st March for in-service candidate cannot be extended because the direct candidates that can be increased, because 31st May for 3 years consideration, in-service candidate that should be fixed. For the direct candidates, they have increased the date, enhanced the date, because they have to complete and they have to appear in the examinations. That has been well settled by this Honorable Court. In 2012, we are having 5 years for in-service candidates. We changed it to 3 years. That was also again challenged here. And they went up to Honorable Supreme Court. Supreme Court allowed them that 3 years in service should be taken into consideration, not 5 years from the next year. So we are having the 3-year service. Here in this case, the petitioners have also applied in direct quota. It's not that they are not in a position to apply for the registration, because in
But
service.
at the same time, they want to take advantage of this position also.
No.
It's wrong in it.
No, my lord, we have not changed, because after facing so many complications and cases, we have fixed up to 31st. So in case of direct candidates, the date is of 31st of March. That we are allowing them. So I will get instruction in this, because they are not deprived of, they have already applied in the direct category mandate. If the matter is going in their favor, we can consider them before
That we have
counseling.
done
with them.
without prejudice to our rights, because I have advised them at least you should make an application as a direct candidate. If will ultimately otherwise, because 2 days only left. So therefore I advised them and they have also applied without prejudice to their rights and contents are raised in the application.
No, but in that circumstance, their cases can be considered only as general.
Right,
Yes,
right.
that's
Only as general, not as in service.
Yes,
That is the
direct candidates, general.
Let us see that clause again.
yes. Yes, ma'am.
You were referring to.
Yes, you'll also come to page
eligibility.
26 to 27. NB. The cut-off date of 31st March mentioned above is subject to change as per any change in schedule of NEET PG. What does it mean? That means my submission is they have specifically fixed this. Particularly in service candidates, you'll also look again. They have fixed it to 31st March at serial number 2. And there are 2 categories of candidate. One is a direct candidate, the other one is in service candidate.
My lord, in NEET PG, there is no in service and direct. It is only the candidates they are eligible, they have to apply. In the state quota only, we have got in service and direct candidates. That's what state has made this. In NEET PG, we don't have that in service and direct candidates eligibility.
No, but the state quota is also based on NEET PG, no?
Yes, my lord. Yes, my lord. In service, we have fixed for that.
Where is that, Mr. Rautra, that for in service?
Yes, that page 26, bottom middle. An in-service candidate is one who at the time of application and under employment of the government of Orissa, such and such, and has completed a length of 3 years of service, including all categories of employment like contractual, temporary, ad hoc, regular by 31st March of the current year of admission. And this is qualified by the NB.
No, but why will that not apply in your case also, by which that has been extended to 31st of August?
That they have not extended. They have not extended because this notice, they also look to that. Admittance, they have not extended. We'll also look again to that.
No, that
they have not extended. So far, the Council of PG Medical Council, they have not extended.
Then what is this?
Page 35.
Annexure 3?
Annexure 3, that is by the National Board of Examination Medical. But appearing in the NEET PG, the NEET PG 24s are now be conducted on serial number 2. And the cut-off date for the purpose of eligibility to appear NEET PG 24, NEET PG 2024 shall continue to be 15th August 2024. We are concerned with the counseling now, PG counseling.
No, but whether this does not extend the.
No.
Why?
They have not done it. This, online also 31st March. Till now it is on online 31st March.
Wherever 31st March appears.
That is NEET PG. Here is the PG medical counseling. That is NEET PG. NEET PG also condition there also. And the current year, they have specifically said current year. That is why they are qualified with NB.
Cut off you are referring to 31st March that relates to 3 years of service?
Yes, yes.
Yes, 3 years of service. And they say that NB, that means that is also automatically qualified with the NB. That is because resettling of NB will need
Subject.
yes.
Subject. Yes. My lord, what?
The 31st.
Reschedule. And they reschedule.
Yeah, yes. Should be extended it. Right.
Since my lord, since 2012.
How they will be affected? That I
My
don't
lord,
think-
since
Normally they were not coming within the zone, but because of this extension, they will come within the zone.
Right, sir. Right.
My lord, since last 12 years, this has been done.
No, but you should take a decision, no? This note requires that the cutoff date of 31st March.
Yes, ma'am.
This is referable to in-service candidates at page 26.
Yes, my lord.
And then it says mentioned above is subject to change.
Yes,
That is subject to change. And then it says as per any change in the schedule of NEET PG. So that will change subject to any change in the schedule of NEET PG. So schedule was changed. Or all India counseling which will be notified. Have you done that? That is the only
No,
question.
I will get the instruction, my lord, because today I got the brief. And my instruction was I have gone through the other cases, similar cases. I have found in one case after NEET's congendum, we have issued a congendum that has been passed by this honorable court that you cannot do for the in-service candidates. You can do it for direct candidates. That judgment is there. And my lord, NEET, the examination they have rescheduled. They twice or thrice they have rescheduled. So lastly, that has been concluded. So I have no instruction whether they have rescheduled or not. What is the state of affairs? But the only thing is that because we are given 3 days, 4, 5 days.
So by this, those who had appeared on the NEET earlier can qualify.
Yes, no, those who have completed
Mr.
3 years of service.
Two aspects.
Yes.
One, this clause is not mandatory. Like it does not mandate that if there is any change, that will require to be changed.
Subject.
It just permits them to take a decision, to notify, and this will be subject to.
Yes. Subject to yes.
Subject. If they do it, it's all right. If they don't do, they don't do. There is no compulsion.
The very purpose of this NB will be.
What is the purpose? For you?
Purpose is subject to change means if the
No. What purpose? See, you knew at the time of filling your application, you knew whether you are eligible or not, whether you had completed, you are going to complete 3 years as on 31st of March or not. It is not that you had to file a different application.
No. In fact, what they have done, if you also look to page 31, initially it was fixed to 31st March by the NEET. So accordingly, they fixed it to 31st March. But the subject to that means they usually.
All right. Let us take it differently. When you filed your application, whether you had the eligibility as on 31st March 2024 or not.
No.
No, my lord.
You did not have.
No.
Then how could you claim?
Because of this NB, my lord. Because I also look to again that that is another condition at page 26 must have qualified in the NEET PG of current year. What does it mean? Current year means.
You are right.
Sir.
You are right. Therefore, we can't compel them to change. We can inquire from them whether they intend to do it or not.
So you also at least let them.
Yes.
What is the then purpose of NB? It is just.
Challenged by the candidates who had already qualified.
Yes. I was the counsel. He knows.
He was the counsel and he succeeded in the case. And we cut down again to
That is a
31st
totally
of March.
different matter. I'll show you.
No, that is the same matter.
No, that's right. That's
And in 2012, my lord, when we changed this,
All is drama may not use the role assigned by the client is conducted. Either this side or that side.
No, that was I'll show you.
Martin will come up for me. Candidates have already qualified.
No, it has not been started. In that case, it was already started and concluded.
just now we have called for the applications for registrations.
Just now it
Nothing
is
has been
called.
started.
That is. It has not been started. That is why Lord rightly said, let him take instruction.
Clause 6 of the clause F of the postgraduate bracketed medical selection Odisha guideline guidelines for counseling and admission of candidates for PG bracketed medical and MBBS PG like and post
And post MBBS.
For postgraduate / medical, postgraduate / diploma bracketed medical courses in the medical colleges of Odisha lays down the eligibility condition. Clause G of the said guideline refers to different categories of candidates that is A, direct candidates and in-service candidates. Subclause G of clause 3 of the guidelines reads thus. Subclause 2 and 3 of clause G of the said guidelines read thus. Stop. Mr. Retiral and senior counsel appearing on behalf of the petitioner has submitted that in the note below, clause 3, it is specifically mentioned that the cutoff date of 31st March is subject to change as per any change in the schedule of NEET PG and All India Counseling. And or All India Counseling, which will be notified. So stop next. Drawing our attention to the annexures in the writ petition he has submitted, that the NEET PG examination, the NEET PG was rescheduled.
Rice or how many times?
Rice.
Finally.
Rice.
And finally, it was fixed to 15th August, 11th August.
It was initially notified to be held on
3rd March.
3/3/2024. So finally, the NEET PG was held on
11th August 2024.
11/8/2024. Now, in the said background, he contends that it was obligatory for the authorities to have addressed to the issue of it was obligatory on the concerned authorities to have taken decision on the point of change of the cutoff date in terms of the note below clause 3. Clause G bracketed 3. Below clause G in the guidelines. So stop. List this matter on 1 week, or we can take up even on Wednesday.
Yes, my lord. Because it will, from Bulla, I will get all information, everything. It is from Bulla, PG Council is from.
What is that?
No, I will get all information, everything. But Wednesday will do.
Wednesday, within first 5 cases, so as to enable learned counsel for the DMET to seek instructions.
And PG Council, my lord. PG Selection Committee also both.
And PG Selection.
One line cannot. We have applied, the petitions are applied without prejudice to the rights and contents raised in the writ application as a direct candidate also. So we also record it so that we have applied within time. Yesterday we have applied.
Oh, it is. There is a direct deadline. We will consider for them. No. They have already applied. They have to check up their.
Without prejudice by rights, sir.
Yes, that is there. Otherwise, we will consider.
The petitioners in the
yes, we have
application have applied that the petitioners are in service candidates.
Yes.
And without their prejudice to their rights to be considered as such, they have also registered themselves for counseling as direct candidates. All right.
The other case, you also allow me application for amendment because
first Mr. Pliko.
Second one is 24711.
Yes. This order is 27118.
That will also cover the other case, but only there I have filed the application for amendment.
What is that?
WPC 26430 of 2022. Amendment incorporating this notice which they have issued. Yes. Because it was filed earlier. Party also, yes.
PG Selection Committee.
PG Council's included party.
So, make him order.
I think also consulted amendment allowed.
How many was making?
I'm serving a consolidated copy of the writ application. So record that I've already served copy. The second case where amendment was done.
WPC 26430.
Consolidated.
Yes, because already said, same order, same.
Next Wednesday, when we are taking
Wednesday. Coming Wednesday.
Wednesday, 13th.
13th. Yes.
Supplementary list item 21.
Because I'm on the virtual mode, my lords. Kindly come to your lordship's order, lordship's order dated 10/9/2024, para 6, my lords. 10/9/2024, para 6. My lordship's got it, my lords.
Let me see, yes.
We are of the prima facie view that the opposite parties have flouted the court's order dated 5/7/2023 by not adhering to the time schedule as mentioned in this said order. The court will proceed further in the present matter depending upon the subsequent conduct of the contenders. Now, my lords, thereafter the matter has been listed on 1/10/2024, 3/10/2024, 7/10/2024, and 8/10/2024. On 8/10/2024, an submission was made by the learned counsel for the state that all the dues of the petitioner has been paid. And my lords, Justice Rothwa had said that you file a compliance affidavit that will satisfy the parties. Because my humble submission is that nothing has been made, save except of rupees 4,58,000, which is the differential pay that I was supposed to get, and I filed it by way of an affidavit. But till date, my pensions, not a single penny has been paid towards my pension, which I have not been getting for the last 17 years. My pensionary benefits, none of the pensionary benefits have been paid. And no affidavit has been filed by the state government till date.
Last 17 years means your application was probably allowed last year. Thereafter only it could be paid.
Before that, it was before the state administrative tribunal. Before that, it was before the state administrative tribunal.
Whether the gratuity amount has been paid.
No, my lords.
Gratuity amount has not been paid.
No, my lords. Your lordship may kindly come to flag A, which is my affidavit which I have filed. Flag A. Flag A, para 3, my lords. That's an additional affidavit which I have filed as per your lordship's observation that I have to take instructions in the matter. An electronic transfer of an amount of rupees 4,58,005 was transferred directly to the account of the petitioner on 15th of February 2024 without prior or post intimation to him. There has been no official commitment.
Let us come to paragraph 2 of the order.
Para 2 of the order.
42, 46, 47, 48.
Yes.
Let us proceed one by one.
Yes,
whether
my
the
lords.
gratuity amount has been paid or not.
No, my lords.
Where is that? Whether gratuity amount has been paid, sir.
My lord, we have stated in our affidavit, we have filed affidavit yesterday only, my lord. And
The affidavit have you served?
we could not serve, my lord.
Give a copy.
I'm having.
It is stated by AGA that compliance affidavit has been filed yesterday itself. Let a copy of the said affidavit be served on learned counsel for the petitioner by tomorrow.
By tomorrow, my lord.
By tomorrow. This case 1 week? Yes.
Item 22.
Yes.
Lordships, actually, the main case has also come. The main, actually, we checked the whole thing. Originally, Your Lordships, there was another writ application where we are the ones who are the shop owners, and we were allowed to construct the shops under the municipality's permission. And then there was some third person who came.
But this contempt is against is for disobedience of an interim order.
Lordships. So
what was the interim order?
We were actually not heard in the first round of litigation. That's why the second round of litigation, which is pending and which Your Lordships have also ordered for. I have listed it today. And the interim order, Your Lordships will find at page 15.
No, we can hear the main matter. We can take up the main matter then.
Your Lordships may just call it maybe another day.
So what is this matter about?
Main matter is basically, Your Lordships, in the first matter, we were really not heard and an order was passed behind us. And because of which the permission which the municipality had granted to us was withdrawn.
Where is that order?
The main matter, Your Lordships.
A main matter?
Your Lordships, I did see the main matter and I found that particular order which was passed in OJC number 11815 of by 1999 is not there. If Your Lordships will call this OJC also, I think that record would be helpful. That was disposed of in the year 2016. 2016 it was disposed.
Record can be.
Yes, it will soft copy report.
Record must have been destroyed, but scan copy must be there. So there the order is because of that earlier order you shall be removed without being heard. That is the order of the division bench.
No, the earlier order was
1811.
disposed of and with the direction of municipality to recall the permission for raising construction.
No, where are you reading?
No, Your Lordships, we have a date chart, that's what we know the order. But Your Lordships will find it OJC order. OJC order. It is, na? No. Your Lordships may just I think if this writ
We will take up the main
this
matter.
writ application, OJC number 11815 of 99, if that is called, scan copy will be available because it was only disposed of in 2016.
What is the number? OJC?
OJC 11815
That was disposed of.
in 2016.
The record may not be available.
Scan copy.
Does this matter on when?
Lordships, 1 week after.
List these matters on 1 week along with the records of OJC number.
OJC number.
11815.
11815.
As requested
Of
by
1990.
senior counsel appearing on behalf of the petitioner. Petitioners or petitioner?
Petitioner.
Common
Item 23. Item 23.
So Rath, you are appearing for whom?
In fact, I'm appearing for municipality.
Municipality.
Other municipality who has recalled that order.
Yes.
On last two occasions, state was directed to file the complaints affidavit. Order dated 12/1/2024.
Whether the order has been complied with or not.
Order is,
What was the order? Yes.
order the state was direct.
My lord,
Wait.
even if, my lord, they have the Tahsildar,
had written earlier that the order has been complied with, the contents of was read that the order was not fully complied with. Thereafter, the Lordship wanted a compliance report, and we have issued 2 consecutive letters to turn up for filing the affidavit. Till then, the Tahsildar is sitting idle. I think it will be
May not be sitting idle, but is not complying.
not complying, therefore, my lord, and it not responding, my lord, not responding. Therefore, Lordship may call even personal appearance of that Tahsildar. No, sir, किसी ने तो दरकार पस
No, there is only.
My lord, I need to personally call and talk to the Tahsildar.
The 29th order, when has the letter been issued?
Letter issued last, my lord,
2 weeks.
on 30th October
Stop in the meanwhile.
2024. The first one is
Tahsildar, which place? Bhubaneswar.
Bhubaneswar Tahsildar?
yes.
Shall be
Tahsildar
required
Bhubaneswar.
to file a so-called reply as to why contempt proceeding shall not be proceeding be not initiated against him for deliberate disobedience of this court's order dated 12/1/2024. Stop. Further, comma, if further, comma, he shall be required to be personally present in court if in the meanwhile no so-called reply is filed. No so-called reply is filed disclosing compliance of this court's order.
On that day, he will file compliance affidavit personally. We will ensure.
Please listen to the order.
If he doesn't file, then he shall be.
Yes, ma'am. That order should be there. Obliged.
For admission item number 33.
But I will start with a copy of the long-awaited affidavit to be filed by my learned Senate. But now they gave me 3 options, out of which I told that I will amend the last option.
33.
So they wanted to respond.
33.
Now they are telling that you accept those 2 options. I have a cursory glance, I have not gone through it. You accept those 2 options. And also they have prayed that the status quo order may be vacated because you have supposed to have constructed some permanent construction and some certain photographs. I need to respond to it. But this was not the issue.
Issue was that because, my lord,
the issue was that whether you have enumerated us as street vendors. And if you have enumerated, you told that yes. But I will tell from several orders of this court that they are playing hide and seek. And then they told that yes, we are street vendors. If you are street vendors, give us the identity card. Rehabilitate it. If you cannot rehabilitate at this point of time, you have to rehabilitate at some point of time. That is the issue. But instead of that, they are now telling that the construction, permanent construction, is to be vacated and all these things.
We will see, Mr. Mohan. Yes, Mr.
My lord, 26(9) order, Lordship clearly observing that order, when I submitted that there is a permanent structure by the petitioners, although they claim to be street vendors, they have constructed buildings comprising 15 feet by 20 feet size. That's the reason I filed, and Lordship, there is an order of status quo for which
you shall be. See, on public road, no one can be allowed to have any pakka construction. So if you have any, you can remove. That liberty you have.
Unless until, my lord, there is a modification of the order, because status quo in respect to the possession. So that's the problem. Status quo in respect to the possession is coming in between.
Yes, Mr. Mohanty, we can modify that order to that extent.
No,
Status quo shall be.
Your lordship sees the photos. That is a soup shop with a table, and that is a permanent construction. But they must give specific allegation that who are the persons so that I can refute at least.
Mr. Mohanty, if there is
Now, under this grab of this blanket order, my lord.
no question of blanket order, if you want, the eviction should be done in some videographies should be done of the eviction process.
It's also done.
Can be done.
It's also done, man.
But I will come back
please, please. If any obstruction is there, see, there are two things which should remain.
If obstruction is there should be removed. Another thing is that if they have admitted us to be street vendors,
that we are there to protect their rights.
They must enumerate us, give us identity card and other things.
Their rights shall be protected. Yes.
They can just throw mud on me and get away from their responsibility.
Mr. Mohanty and senior counsel appearing on behalf of the petitioner states that a copy of counter affidavit or what?
Additional affidavit.
Additional affidavit has been served recently.
Today itself in the court,
which he requires to consider and file rejoinder if so advised.
If necessary.
If necessary. To stop this matter on when?
10 days after.
10 days.
19.
You file the instruct your associate to file it in the
Yes, ma'am. That I'll instruct. File. Registry.
Yes.
Interim continue till then.
Interim orders shall continue in the meantime.
This is the graph. This is the graph, my lord.
Don't laugh, wisdom. There are a lot of things to say when you are appearing for a public authority. You are not appearing for a private.
No. I am appearing
You are appearing for a state authority.
We will see, Mr. Mohanty, both of you are safeguarding public interest. You are also safeguarding the interest of.
A tendency, I have instructed all my law officers when I was the Advocate General, that state is our client, not a particular officer who are not here to defend.
Therefore, we are saying that both of you are safeguarding public interest.
And when there is a tendency with the councils, my lord, when they appear
don't make those comments.
That
is not in good taste.
Unbecoming on your part, at least to make
Mr. Don't enter into such. Yes.
Item 34.
I'm paying for writ appeal 1194.
Just a minute. Item number 34.
Item 34, second item, my lord.
Yes.
1194 of 2022.
Yes. Let him.
No,
begin.
this is these writ appeals are dismissed because of non-gender parties.
So may remove certified copy not filed, delay is also there.
My lord, I may be allowed to make my submission, my lord, minimum.
Yes, sir.
1194 of 2024-22, they have filed a writ appeal without making all the parties who were before the Lord and single judge.
All right.
That is my humble submission before your lordship, my lord.
Who is in the first case?
It should be dismissed in limine because of non-gender parties.
Mr. Mishra, please, will you wait, please, for
Yes,
a while?
Yours is the second item. We are taking up the first item.
Yes, who is in the first case?
I am for the respond number 1.
Who is for the appellant in the first case?
The all case,
What do you
state is the. Let it come next to it because the batch of cases here for defects are there are now the removed. The direction. So I have to examine these or not. Let it come next to it.
All right.
Along with along with another 5 cases is there.
Give the list.
My lord, Supreme Court has already settled everything, my lord. Be that as it may, my lord, in so far my case is concerned, my entire submission before your lordship is that there are 20 petitioners before the
All
Lord
right,
and single judge.
we will
They
consider.
have made one person as a party. Therefore, it should be dismissed in limine as
All right.
non-gender party.
All right.
The number of applications, defect has been pointed out in probably 2, so you get ready with the case.
List these matters on 2 weeks. So as 2 weeks as requested on behalf of.
And I've been arguing this matter from 93 before the Apex Court.
Yes, defects, if any.
4.4, my lord.
One moment.
The defects must be removed in the meanwhile. Yes, Mr. Mishra.
My lord, my second case is 1194 of 2022. There were 20 petitioners before the
Mr.
Lord and
Mishra,
single
all the cases shall be heard on the next date. Your
But
contentions are-
without making the other persons as parties.
That we will hear. That we will hear on the next day. Today he's praying for time.
And I've been arguing this matter from 93 before Supreme Court, my lord. The unfortunate case, Supreme Court has settled the law.
So that we will hear you on the next date.
As your lordship pleases.
Since he is handling the brief for the first time today, we are granting him some indulgence.
That predicament I can understand, my lord. That predicament I can understand.
My lord, sub item 4, my lord, WS 614 by 23 is a separate matter. Similar, it is job contract matter. Currently, what charge pencil.
So we list it on another date then.
My
WS 614.
after disposal selfie, my lord. Nityananda Vishwa.
SLP is twice dismissed in different cases, similar matters. I've been acquainted with this case and had appeared before the Apex Court since 1993.
Yes.
Lordship, fix a date, my lord. It should be because
These appeals arise out of the same order. Same order. All appeals arising out of the same order should be listed together.
Item note 35.
persons continuing for 40 years are not getting many retirement benefits. I was a party before the Apex Court and I put the matter from 1993 onwards, my lord.
35.
35, my lord. The matter relates to, my lord, that tender of loading and unloading under Beverage Corporation, my lord. So your lordship on the last occasion has granted leave, my lord. On the last order, my lord, your lordship has granted leave to go for fresh tender, my lord. So in the meantime, corporation has already, my lord, quoted the paper.
Yes.
I'm just filing a memo, my lord.
So that you just wanted an affidavit which he has filed, right?
The term has also come to an end.
On the last occasion, I had filed the affidavit. So now we have already published the fresh tender, my lord.
You are for?
I am for the opposite party number 2 corporation.
When counsel appearing on behalf of the Odisha Beverage Corporation states that the tender in question has been cancelled.
That has been cancelled.
And fresh tender floated.
In question
And
has
fresh
been
tender
cancelled.
notice has been floated, my lord.
And a fresh tender notice has already been floated. First off, in such view of the matter, this rate application has become infectious and the stands disposed of accordingly.
Right.
Yes.
36.
And item 36, I am appearing for the respondent, my lord. So similar to item 34, my lord. WA number 432 of 2024. Similar.
No, my lord, so item 36, possibly I don't understand why my friend is saying it is similar to 34.
Batch matter it जो तेले सबो matter पे ना से जो dealing थला. Dealing संगे this one ना.
So the same order is under challenge.
Yes, madam.
The same order of learned single judge is under challenge.
Similar order, sir.
Not similar. We are asking, is it the same common order or different order?
Different order.
Then
36, my lord, where in this writ appeal we have assailed the order passed by the honorable single judge, where he has passed an order without giving notice to the other side with a direction to regularize the services of the petitioner there.
That cannot be done, Mr. That we can write.
now, why do you say it is connected to item 34?
This is the first item 432. WN 432 2022 is a employee of work charge employee, retired work charge employee seeking pension, my lord.
Maybe we will consider the merit of the order which is under challenge in the present application.
There is not a case of pension.
Everything.
I'll take up 2 weeks after my.
Why 2 weeks? So we'll argue it tomorrow.
2 weeks.
And it's a very short point. What he is saying that the order was passed on the very same day without giving any opportunity of filing counter affidavit with a direction to regularize. That could not have been done.
That upon the judgment taken, relied upon, are not applicable to the case of work charge employees. In respect of work charge employees, there are other judgments we have reflected in the writ appeal.
Kindly taken up one time may be granted, madam. Next week, madam.
As requested on behalf of the respondent, this matter on 1 week. Yes.
Item 37, can it be called next week?
37. All the matters will be listed on next Tuesday. The rest of the matters.
Contempt
matters are not urgent.
Listed today,
Yes.
item 64, last item, already not reaching. So let it come under case admission, my lord, on the next Tuesday.
Make a mention on next Tuesday.
Yes, sir.
Contempt matters are not urgent.
Mr. Ponda, just check 64. File compliance affidavit.
Item 57 plus. Yes. I humbly pray this matter may be called along with the CONTC number 5657 of 2024. CONTC, one contempt application.
Complaints has been not there, my lord.
37.
Why?
Plus the next week, any day.
Why?
Because both arise out of the same cause of action and both can be disposed upon one day.
Both of the
Already complied plus. CONTC 5657 by 2024.
My lord, item 45. Item 45, in last 2 weeks, it was listed, but it was not reached. Kindly taken up tomorrow, otherwise it will be interrupt session.
All right, we will try next.